You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Please rise. Hear ye, hear ye, hear ye. The Florida Supreme Court is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning, ladies and gentlemen, and welcome to the Florida Supreme Court. Chief Justice Kennedy was unable to attend today. He will be participating in all of the oral arguments, which are, of course, are recorded, and participating in the deliberation of the case. I am going to call the first case, which is Hall versus State of Florida.
May it please the court. Good morning. I'm Chris Quarals, and I represent Dante Hall in this direct appeal from Lake County, Florida, wherein Mr. Hall was convicted of, among other things, 2 counts of first-degree murder and was sentenced to death on one of those. The jury recommended death 8-4 for the murder of Anthony Blunt, and they recommended life for the murder of Keeson Evans, and the judge followed both recommendations and sentenced Mr. Hall to life on one and death on the other. This morning, I'd like to focus on almost exclusively on one issue. I have no guilt phase issues. We contend that the trial court erroneously found and that the murder of Mr. Blunt was especially heinous, atrocious, and cruel. This was a robbery gone bad where Mr. Hall and 3 of his confederates robbed a house full of partying people after Mr. Hall's girlfriend had received an invitation to be hired as a dancer to strip, and she got some of her girlfriends to come up to a house in Eustis for a party on a Friday night. They got the idea that...
No, I find it very difficult for you to say this was a robbery gone bad. Isn't this the case where did they come in with AK-47s in this?
2 of the men were armed with guns that were similar to AK-47s,
and,
yes.
I mean, there was a lot of shooting
There was a lot of
in
shooting.
this case. And
yes,
so
there was.
It seems very...
Well, and that's why the judge found a great risk to many people, and we do not contest that on appeal. So the 3 aggravators he found, the contemporaneous convictions, prior violent felony convictions for the murders and the attempted murders, as well as great risk to many, and
pecuniary gain.
Pecuniary gain, correct, and also, and they conceded, the state conceded that the murder of Keyshawn Evans was not especially heinous, atrocious, and cruel. This was literally...
Now, is Mr. Blunt or is Mr. Keyshawn the one who was sort of begging for his life?
No, he wasn't begging for his life. He was...
begging for help.
He was begging for help after he had been shot, and he lingered and remained conscious, I believe, for 30 minutes before he died a couple of hours after the shooting.
Isn't Blunt the one that told him to that the money in the other room?
That was Mr. Evans.
Evans, okay.
And when the money was not in the other room, somebody came back and Mr. Evans was shot in the head.
This one is a situation that if HAC is to be applied, it's going to have to be applied in connection with the lingering death, the bleeding to death, and that kind of thing.
Correct.
And in this area, it does seem that we've got cases sort of all over the place, and certainly it's not, we know for sure, it's not according to the intent of the shooter. It's got to be viewed from the victim, and you agree with that?
I agree with that.
And we have some where there are shootings, and they say, no, you can't have this, yet there are strangulations that maybe even produce death sooner. And yes, those are HAC. I mean, there seems to me there's got to be something, some kind of view where you step across the line. You understand what I'm saying?
Yes, I understand what you're saying.
Trying to understand where should that be? Where is the law of Florida? Because it seems to have that line has sort of moved.
It has moved somewhat, and before, the intent of the murderer was a factor that this court did consider. You receded from that in subsequent years, but the consistency of all the cases where HAC, especially heinous, atrocious, cruel for short, HAC has been upheld by this court where there's been a shooting in the course of the event is where there have been acts that the defendant must engage in some action to torture the victims or subject them to pain or prolonged suffering. And all of the ones where there have been shootings, the shootings were preceded by long episodes of either rape or driving them a long distance where they knew they were going to be killed.
So you think that's the thing that has tipped those over?
That's
correct. It's been the predicate conduct before the actual firearm death kind of thing.
Absolutely, and that's consistent. The cases that the state rely on, Henyard, Wyatt, Hannon, and McGirth, there was substantial time between the shooting, the death, and while the defendant was still in the act of committing the crime. Perhaps the closest case is McGirth, where the victim was shot once in the heart, and then she collapsed on the bed but was still alive and was begging them to call 911. And for 30 minutes, McGirth and his co-defendant stayed in the house. even made the victim who was shot in the heart go to the computer room and then try to unsuccessfully to order some cellular phones on the computer, and then she crawled back into the bedroom, and then ultimately 30 minutes later, after the first shot was fired, McGirth shot her in the head, and also her husband, who survived.
This always strikes me, because did you?
No, go ahead.
No, go ahead.
I was going to follow up, though. Even if we accept that argument, where does it take us? So, I mean, there's two arguments here. There's one,
yes,
okay, about the HAC, but even if that's not, we have other aggravations.
We do. And I think if this court upholds EHAC in this case, you're going to definitely have to recede from Tefteller, which was
what?
Tefteller versus State, where there was a one shotgun blast and the victim lingered, and the doctor testified that he lingered for 2 or 3 hours, longer than Mr. Blunt, and remained conscious, and was on the operating table, and said they testified about the final glide path, and he said, I feel that I'm going, and they talked about how the patients sometimes know that death is imminent and that they're dying, and this court said the fact that he lingered after the shooting, the quick shooting and the robbery, was of no import
But
as far as
I think where Justice
EHAC.
Lewis was starting to go was, so we strike HAC. Isn't it harmless beyond a reasonable doubt?
Not in this case, because, and we have a good evidence of that, a good record for that, because the state asked for, and the defense agreed, that they do interrogatory verdicts on the aggravating factors. And remember, they did not submit HAC as an aggravating factor for Mr. Evans. Only the first 3, which they unanimously found on Mr. Evans, yet still recommended life. On Mr. Blunt, the only additional aggravator they were instructed on, over objection, was EHAC, and they found all 3 of the ones that they'd found on Mr. Evans unanimously. They found EHAC 11-1, and they recommended death for the murder of Mr. Blunt by a vote of 8-4. So the only difference between the consideration by the jury of the aggravators was that EHAC on Mr. Blunt, the one they imposed death on. They voted life on Mr. Keyshawn Evans. So that's what the defense argued in their sentencing memo, and the judge's findings of fact read like, especially on the finding of EHAC, he cites all the correct law of this state, and then incredibly concludes that it was. Especially heinous, atrocious.
Well, let me go back. I want to go back to the HAC aggravator. You made this is an interesting point here on these findings of the aggravators. I've been troubled for some time, and I think Justice Lewis began to talk about it, that we have, the way we've got the law, if you are someone that comes in with an AK-47 and, maybe intending to do harm, and you're a good shooter, there's no HAC because you know how to shoot somebody and you can kill them immediately.
Right.
If you're an inept shooter, you can end up where you think you're hitting them where you should, but they linger. So we have sort of instead of it being conscienceless, pitiless, or unnecessarily torturous, we've got how good the shooter is would determine HAC for shooting deaths. If we go, and so this is, but on the other hand, you've got somebody who doesn't come in the house with a gun, and something goes wrong, and they decide, I'm going to strangle them. Same thing, they want to kill the person, but now they start to strangle them, and we've said strangulation deaths qualify for HAC. Now, that's been the law since, I think, before I got here. How do you explain that difference, and what would your argument be about, well, if it's the same thing, if when you are going to kill somebody, if you don't kill them immediately, it's going to be HAC, whether you do it by guns or strangulation or knives. And I'm not, it's not my view, but I'm asking what's not logical about that. Why should somebody who's a professional killer get less of an aggravator than somebody who's an inept killer?
Well, the whole purpose, I think, of that this particular aggravator is to try to limit the suffering of the victim. And to that extent, I think this court was somewhat wrong in receding from the mindset of the defendant, but you have.
But the mindset, really, we've said, is still, it's not an intent.
Correct.
But it does have to be done with sort of, would be recklessness or,
Correct. And that's why I think a strangulation, it's not like the movies. Strangling somebody takes some time, and you have to deliberately get in there and choke them, and it's even with a garrote. It's where somebody, and this is the classic example, the trial judge in this case wasn't even sure that the bullets that resulted in Mr. Blunt's death came from my client's gun, because there were lots of people shooting. And this was just it was like he said, I'm going to make the chopper dance, and it was literally chaos. The whole incident from entering the house to leaving the house after the shots were fired was 10 minutes. And the shooting itself was a matter of, maybe 20 seconds, 30 seconds.
Well, I thought, no, that they did have evidence based upon the other witnesses on the size of the people to identify who the shooter was of this person.
Well,
they may not have ballistics, but did they not have testimony?
They had testimony that my client shot the first Mr. Evans.
But not
no, not Mr. Hall. I mean,
not by description.
I mean, not Mr. Blunt. No, I don't. Not even by description. Right. They two of my client by description and another person had the automatic weapons, and both were firing. Everybody was firing, I believe, but it was pure chaos, and they could not say which gun, whether the bullets that killed Mr. Blunt came from my client.
That's what I asked.
Killed him. That kind of gun.
I'm not sure about that. I think that he had 3 wounds. One went through the fatal wound went through his chest, one went through his arm, and one, I think the other 2 would not have been fatal, but the one through the chest cavity that cut aorta was the fatal wound ultimately. And the fact that he lingered was not caused by deliberately caused by my client's action. He just lingered. I mean, he survived. He stayed conscious for 30 minutes.
And that's not. We've always said that's not necessarily for this aggravating factor that your client intended.
Correct. But he still the case law says must engage in some action to torture the victim or subject them to pain or prolonged suffering. And that, like I said before, it's the entire, all the ones where it's been upheld, where it's been the result of shooting, it's not been because the victim lingered, it's because there were separate acts apart that either occurred while the victim was still alive, either they shot him again or they made it clear they were gonna kill him. This was literally seconds that the shooting occurred, and the fact that he lingered, this court would have to recede from its case law to uphold
Was this a joint penalty phase?
Yes, it was.
And so Mr. Blunt and who was the other victim?
Mr. Evans.
Mr. Evans was the other victim that died. So they would have presented different mitigating circumstances during the penalty phase, correct?
Different mitigating for?
No. The penalty phase includes the aggravating circumstances and the mitigating circumstances. I mean, you said earlier that even though they found this HAC for Mr. Evans,
yes,
they recommended.
No, I'm sorry, they did. No, it was the state conceded that HAC was not applicable to Mr. Evans because he was shot.
I thought your argument was that even though they found it for him, they recommended a life sentence.
No, Your Honor.
Okay.
They did not. They were not allowed to consider HAC for Mr. Evans' murder.
What you're saying is the only. I mean, it's I think a good argument that the only difference between the 2 shootings was that the jury was instructed on HAC for one and not the other.
Correct.
Are we going to hear anything different from Ms. Davis when she gets up as to what would have?
I don't believe so. And additionally to the fact that the jury was considering that additional aggravator for the one murder that they recommended death on, the trial judge gave it great weight in his findings of facts. So I clearly don't think it could be harmless, especially, and this is sort of deals with proportionality argument, the second point. The jury didn't hear much of the evidence about his abusive childhood. They heard some. They heard about his school problems and drug use and some family problems, but really a lot more of that came out of the Spencer hearing. Why they did that, I don't know, but the judge found the statutory mental mitigator of that his ability to conform his conduct to the requirement of the law was substantially impaired. And I believe in the argument portion of my brief, I didn't make that clear in the statement of case and in the judge's order. It is clear that he did find that statutory mental mitigator. I want to reiterate that. Additionally, he found lots of other non-statutory mitigation and gave it some weight. And even the statutory mental mitigator, he only gave some weight, I believe. And so the jury, even without hearing all that, still only had an 8-4 death rec on Mr. Blunt.
Well, the jury had to have heard some
they did.
mitigation, or they would not have been in a position to make any recommendation. So the mitigation on each is unique to each, is it not?
The mitigation, aggravation, right. Or mitigation?
Mitigation. I mean, a jury can't recommend death without a mitigation aggravation finding.
Correct.
So the jury did hear some mitigation.
They heard mitigation, yes.
So that's my point, is that mitigation is very particularly unique to that individual. So
to my client.
And to the others. And to the other defendant. So I'm trying to understand how this all fits together.
Well, it wasn't a joint trial.
No, I think let's just make sure joint
victims. I'm sorry. Yeah, not
okay.
I'm sorry.
Right.
I'm
so
sorry.
There was he was convicted of the murder of two victims.
That's correct, Your Honor.
And then the penalty phase was for the murders of the two victims.
Yes, ma'am.
The mitigation, since it's one defendant, was the same as for both
That's
victims.
Correct. That's correct.
What you're saying is the only difference in the aggravation was one was instructed, the jury was instructed on HAC.
That's correct.
And the other one, the state conceded no HAC.
Yes, ma'am.
And the jury in that case, what was the vote for life in that case?
I believe it was 6-6.
But on that case, we don't have, in the other victim, do we have the same kind of information that the guy was begging for his life and moaning and groaning? I mean, there is some difference.
He wasn't begging for his life. Let me make that clear. He was begging for medical help, saying he didn't want to die long after my client had left the scene and the EMTs were treating him. And they assured him they were going to help him and they would do everything possible.
My question to you was the other victim doing the same thing? Was the other
victim... He didn't survive. He didn't linger.
Okay. That is the difference.
Well, but this court has said what happens if he lingers. Taft Teller's right on point.
I think so we go back around in a circle. I said to you, what difference does it make if we strike HAC? And you said it makes a difference. And
yes.
That's how it came. Now, if we uphold HAC, then at that point, your argument, there's no argument, you lose. Okay, so the issue that I'm understanding that you're saying is that in shooting deaths, unless there is evidence that the defendant either was doing things before or watched and didn't do anything after, that we have not upheld HAC.
That's correct. And I want to amend the vote on the life. I don't believe there is a record of what the vote is. I think it was just, they found all the three aggravators unanimously, but I think on the verdict form for life, it just says life. They're instructed 6-6 is life. I don't know what the actual vote was. I believe
Do we have both of the special verdicts in the record?
Yes, ma'am. The ones the cases state rely on. And so my guy goes in there, robs everybody, sprays the place with an automatic weapon, as does one of the co-defendants, and then leaves in a matter of minutes. And Mr. Blunt survives, and the EMTs come and try to save him and are unsuccessful. He's unconscious within 30 minutes. He's not pleading for his life. He's pleading for help. There's a big distinction. Hinyard, case relied on by the state. A family was abducted.
What is that distinction?
Pardon?
What is that distinction? You said there's a big distinction.
There's a big distinction between
between pleading for your life and pleading for help, but isn't pleading for your help the same as helping me to stay alive?
No, ma'am. Pleading for your life is when the the murderer is standing over you, and you realize that he's about to kill you, and you beg him. And in one of the cases the state relies on, the victim said, "Please, we've got a 2-year-old daughter. Please don't kill me." But that didn't happen here. This was very quick. Everybody thought this was going to be a quick robbery, and they emphasized in the trial testimony, did anybody buck the jack? Did anybody resist? That's slang for resist. Did anybody buck the jack, resist the robbery? No, everybody cooperated. That's why, and the state was pointing out that despite the fact that they were cooperating, pulling all their money out, throwing the jewelry, they just started shooting. And so nobody begged for their life because nobody expected anybody to get killed or shot. So it was really a matter of 10 minutes, and the shooting was a matter of seconds. They were gone, and he happened to survive. But that's under the Tefteller, it's clearly not especially heinous, atrocious, cruel. The ones where you have upheld where the shooting, a family was abducted, mother and 2 daughters. They are taken to a remote location. The two young girls are the victims. They rape the mother within earshot of her daughters. Then they shoot the mother, and the little girls are whimpering in the back seat, crying for mommy. They stop, take the 2 girls out of the car, and take them a short distance away from the car, and shoot them execution style once in the head, as they sobbed and pleaded, and they were killed. Wyatt. There was 20 minutes of abuse. The victim was pistol whipped when the safe didn't have enough money in it. One of the victims was undressed and raped a short distance from where 2 other employees were held.
In this case, there are 4 aggravators, right?
Yes,
Four
sir.
aggravators?
Yes.
So if you eliminate the HHC, why don't you still have 3 in this?
You still have 3, but there's substantial mitigation, including a statutory middle mid.
Why isn't it harmless error?
Because I think well, it's not a matter of just mere counting. It's a matter of weighing, and as I said, the judge gave great weight to the HAC aggravator. He didn't say even without this I would find death appropriate. So I think it's not clear that it's harmless. The state must prove beyond a reasonable doubt that without a finding of this aggravator, the judge would have still imposed and the jury still would have recommended it. I don't think they can meet that burden.
You're saying they can't in this case because there's a special verdict that shows without it as to the other victim that the jury recommended life, and under our case law, the judge would have been bound to give that great weight.
Especially under these facts, yes.
Give great weight to the fact that
that it was especially heinous, atrocious, cruel.
No, I'm saying, I was saying that he would have to, if they had recommended life for this,
yes,
the judge would have had to give that great weight.
That's correct. But he says in his order, I want to make clear, he gives the finding of HAC great weight. But
you make an argument in this since it was an 11-to-1. Was 11-to-1 on HAC
yes,
and
ma'am.
11-to-1?
No, it was 8-4 on the death rack for Mr. Blunt, the victim.
You make an argument that, because in this case, it appears that the aggravator that would have that elevated this for this jury to a death case was HAC, and it wasn't unanimously found?
Well, the fact that it wasn't unanimously found is sort of a side issue, but no, the main issue is the only difference in
it's
their
not a side issue to me, but it may not be to the U.S. Supreme Court. Because
Correct.
I thought you didn't raise a ring issue.
I raised a boilerplate ring issue.
Well, that's what I thought. There is a ring issue.
Yes, there's a ring issue.
But it's an interesting twist on it, which is normally we say if there's a prior violent felony, there's unanimous recommendation on the prior violent felony. But if you have the one, I mean, again, maybe it's a stretch, but it's something to keep in mind for you.
Correct, and that's something I'm sure the post-conviction lawyers will.
But we also have the prior violent felony in this case, right?
We do.
And 2 of the 3 remaining aggravating factors were given great weight also.
Yes.
Great risk of harm to many people.
Yes.
And the pecuniary gain.
Yes, ma'am.
Is there evidence that Mr. Evans would have witnessed other people being shot before he was?
Mr. Evans, yes, there was one reason that they opined, the surviving witnesses opined that he spoke up and said there's money in the back room, which they knew there was not, was because someone, I can't remember who, if that person was able to be identified, was shooting JD, I believe, was a victim who survived for no apparent reason, and just as a show of force. And Mr. Evans, they said, spoke up, said, stop shooting, there's more money in the back room. He was trying to buy time and save all their lives.
What about Mr. Blunt?
Mr. Blunt saw when they came back, he did see Mr. Evans shot in the head, but again, within seconds, all hell broke loose, as they said. And the lights got shot out, and it was black, and bullets flying everywhere. So he certainly saw, well, actually, it's not clear that he did see. He may have been aware, because it's not clear when the lights went out. They were in a tiny Florida room.
Well, seeing somebody else shot or hearing somebody else shot, that's not HAC?
If not if it's a matter, all the case law that y'all have on where you uphold it on a shooting of this sort, there was really a prolonged period of time where there were additional acts. Yes, for example, the little girls I was talking about, they saw their mother shot and raped. Yes, but it was over a long period of time. I mean, all of the cases.
Mr. Quarals, you're in your substantially in your rebuttal. Please finish the
I'm
answering.
just going to piggyback on what Justice Poston said.
I mean, if you look at the cases that the state relies on, Hannon, Wyatt, Henyard, McGirth, all red. Even all red. That was my case, and the girl was terrorized for a month. She kept getting threatened by Mr. Allred, and then he texted he was coming over. She was petrified. She panicked, and then he arrives, and then she hides in the bathroom. This was a robbery. Everybody thought everything was going to be okay. Then it went haywire, but literally, it was only a matter of a few minutes, and my client and the rest of them were out of there. And the fact that he lingered, a tribute to medical personnel who were there, should not be used to support. And
well, the only reason it went haywire is because they started shooting their guns, killing people.
I agree. But
nobody tried. You said nobody tried to.
That's correct.
Stop them.
And that's why we didn't contest the great risk to many. When you start firing indiscriminately.
All right, you have 2 minutes left.
Florida,
if you want to say
room,
that.
that's what happens, but it shouldn't support EHAC. Thank you. Otherwise, it does not narrow the class, and perhaps renders our statutory scheme unconstitutional because it doesn't truly narrow the class. Thank you.
May it please the court, my name is Barbara Davis. I represent the state of Florida. First of all, on Keeson Evans, he was the one that said, just give him the money, everything will be fine. And he said, the money is go down the hall, the money is in a back room. And the defendant said, if that money's not in the back room, you're dead. When the person who had checked in the back room did not find the money, came back out, Keeson was shot in the head, was immediately unconscious.
But but the state conceded that HAC didn't apply to that murder.
Yes.
I mean, if we really go and we say, well, he must have known something was going to happen because they said if it's not there, you're dead. They must have known. There are some, I can see the state going, well, he must have known, but the prosecutor conceded that HAC didn't apply to that defendant. So I don't understand.
It wasn't
to that victim. I'm sorry.
It wasn't that there was no money back there. It's that the person who went to get it could not get into the room or somehow did not access the money and came back out and said it's not there.
And at the shooting of Mr. Evans, this was done immediately when the person came back from the room.
Yes.
And was Mr. Blunt shot at that point or not?
He had already been shot. When they came in, the evidence shows, and first of all, and the judge finds at page 4 of his order that there is one AK-47. He says it's not real clear because there was so much confusion, but There's one AK-47, there's two 9mm, and the defendant had the AK-47, just so we're clear. There were 4 shots fired from the AK-47, 12 shots from the 9mm. When they went in, the defendant said, okay, so let's look at this from Mr. Blunt's view. They're sitting there watching the strippers. 4 masked men come in. Defendant is screaming, "Give it up, give it up. Don't you take me seriously. I'm going to make this choppa dance." They start shooting people. Mr. JD is shot, Mr. Blunt is shot, and the judge finds in his order, page 12, that Willie Shelton testified that as soon as he was shot, Blunt started yelling, "Please, please help me, please help me." And then he was saying, please don't take me, someone help me.
Well, so wait a second. So Blunt is, you said, he's the one in which the death penalty is imposed for that murder.
Yes.
And all we're really talking about, because I think that Mr. Quarles concedes that there are these 3 strong aggravators. But I'd like to just go to this issue, which is, let's assume that HAC does not apply for this victim, for this shooting death. What about Mr. Quarles' argument that the shooting deaths of Evans and Blunt are essentially in the same class? You know, they're a product of, again, reckless conduct, you know, shooting a lot of people, and there's attempted murders and there are murders, so definitely qualifies as a death penalty case. But for the jury, he says the only difference in what the jury was instructed as to each victim was HAC. Tell me what's wrong with his argument.
Because the murder of Keeson and the murder of Anthony Blunt are completely different. Keeson, after people were shot, he was the one that said, just give them the money, we'll be okay. Go down the hall, get the box of money. It's in a shoebox.
Let's use Evans. Are you talking about Evans?
Evans, Keeson Evans.
And this is after the other people are shot already.
Yes.
And the state conceded that HAC didn't apply to that victim.
Yes, because when the person that went to get the money didn't find it, he comes back in and says, it's not there. Keeson is shot in the head immediately. The medical examiner says he was unconscious immediately. I mean, if you look at the MRI, it took half his head off.
So are you
He was
saying
gone.
that the state's position is that if somebody is a good shooter and somebody dies immediately, that's not HAC, but if somebody is less than, even though the same idea, this guy was shot in 3 different times, clearly intending to kill him. There wasn't an issue of shooting him in the leg and then playing around and shooting him someplace else. That is HAC? Is that really where our law has gone in this arena?
I'm saying that in this case, there was no evidence that Keeson was experiencing mental anguish, emotional terror.
Well, it's the lingering and the cry-outs. That's what you say constitute the HAC.
Yes, and Keeson actually said, we're going to be fine, and he was killed immediately.
Don't we also, though, Ms. Davis, have in this area of HAC some cases where people have pled for their lives? One shot kills them and no HAC.
You do, but this is not that case.
Well, okay, but I mean, though, it just seems to me that it's very difficult to find where all these cases go. I'm just trying to see how they've help us mentally put all these together. I mean, and it seems to me we have a case on a robbery of a speaker store, and they line up all the employees and shoot them in series. And I believe there was no HAC in that case yet, and I believe it's called Farina, the freezer case, where they take them victims, and there was a. Where is the symmetry? Where is the consistency that we ought to have in the law, so that you, as a prosecutor and the defendants, can apply this in a logical and correct way?
And that is why you have seasoned prosecutors who know there is no bright line. You can't say this amount of mental suffering ahead of time or this afterwards. But the prosecutors knew. Keeson Evans did not suffer. Anthony Blunt did. He was shot several times.
I guess what I'm asking you, though, and I don't know I got an answer to it, so what we're saying is that HAC will, even if there is nothing that occurs beforehand, that HAC now in a shooting death will depend on whether somebody is a good shooter or not a good shooter.
No, and this does not come down to good shooter, bad shooter. They were very good shooters. The reason they were shooting them in the body parts is to make them give them the money.
Is there evidence in this record that what they did with this victim, because that is they shot him once in the leg or some other part, a non-fatal wound, and then said, now tell me where the money is?
When they came in...
is that the situation? Because I didn't hear that from Mr. Quarles.
When they came in, and this is in the judge's order, the defendant said, give us your money, and then he said, do you think we're playing? If you don't give us the money, I'm going to make this choppa dance. They were not giving him the money fast enough. They started shooting indiscriminately. They did not go up and shoot somebody in the head.
And the indiscriminate shooting gets you the great risk of harm.
Yes.
And this is all, I'm not still sure. Let me go back to something else. I asked you, I agree that these 3 aggravators qualify somebody for the death penalty, but we're also talking about what the jury would have done. And so from the jury's point of view, if they're not instructed on HAC, then there's the same 3 aggravators for them. What then distinguishes why there's a death penalty for one and a life sentence as to the other victim?
And this question and Justice Lewis's question, if we look at Anthony Blunt, he is shot 3 times in area where he is bleeding inside. He is saying right at that point, please don't take me. He is saying, don't shoot me again. And then...
And was he shot again?
It's not real clear.
So in other words, after somebody says, please, they see they're still moving, and the person says, don't shoot me again, and they shoot them, that's not HAC, but if they don't shoot him, it is HAC?
Keeson Evans was not begging for his life. Keeson Evans said, everything's going to be fine, just give him the money. He was shot in the head, he went unconscious. Anthony Blunt was shot and begging for his life, and they come back and shoot Keeson in the head right next to him.
Does it matter whether he was saying,
right there.
Does it matter whether he was saying, don't shoot me, or help me?
He said,
that's what your opposing counsel said, is what he said was, help me.
And please don't take me. Now, and it was not 10 seconds worth of shooting, it was 5 to 10 minutes, by the way. And then after they shot Keeson, they collected all the Gucci bag, the jewelry, everything, they left. So it was 5 to 10 minutes before 911 was called, and they were still collecting the jewelry and robbing them while Anthony is sitting there suffering, has just seen Keeson's head blown off, not knowing what is going to happen to him, saying, please don't take me.
Well, he's already been shot then. Was it? But he was already shot.
Oh, yeah.
Well, let me ask you this. What would happen if, in this situation, the jury had found the 3 aggravators that are not in question here for both of these cases, and then the jury had recommended life for one and death for the other?
Well, if Keeson was heinous atrocious...
No, I'm saying, assuming that there was no heinous atrocious, and just the 3 aggravators that we have, and then the 3 aggravators were found for the other murder also, but for Mr. Evans, they do the life sentence, and for Mr. Blunt, they do a death sentence. What would have been the result on appeal if there was some question as to since he got life for one, shouldn't he have gotten life for the other? I mean, that's in essence some of the questioning that seems to be here.
Well, and that's, as Mr. Quarles said, it's not a counting process, it's a weighing process. The death of Anthony Blunt was clearly more egregious than the death of Keeson Evans.
You're saying even if you don't find the HAC, that the circumstances of his death would require not required, but a death sentence would be appropriate, even if a life sentence is given to for the death of Mr. Evans.
Absolutely, absolutely.
Wait, I'm a little troubled by that, because that to me seems to say we have a standardless system. I thought the whole reason that this aggravating, mitigating situation came about was to sort of narrow the class and to have some consistency in it, so that that there was the consistency if you found certain mitigation and certain aggravation, because you are seeming to say you can give death for the same mitigation and aggravation when in the same jury can give life. I'm not that's standardless then, isn't it?
I'm saying you don't count. Oh, he's got 3 aggravators,
Oh, no, I
and he's
understand.
got 3 aggravators.
Well, but I understand. I mean, one may be shot in the head, and the other may be shot in the heart. I mean, he's still dead.
However, now...
But it's got to satisfy. I thought it had to satisfy aggravators to be elevated. Not just that there's different deaths, but it had to, that the aggravation, it's aggravation and mitigation. If it's identical...
It's not identical. And so first of all...
Well, that's what the question was.
First of all, you have to assume that Anthony was killed the same way as Keeson in order for them to be identical, and they were not.
Well, no, from a standpoint of mitigation and aggravation, I don't agree with that.
Well, if you want an individualized sentencing to go on, you're going to look at how Keeson was killed and the entire episode. And then individually, you're going to look at how Anthony Blunt was killed
Well, it's
and
standardless
the
then.
entire
We can't
episode.
tell a jury if we're not looking to aggravators and which aggravators apply and mitigation and what applies, then we have a standardless system. You can do anything you want with them. I didn't think that, I think we're getting pretty close to having a real problem with this death statute if this is the way it operates. You may be right, but if that's how it operates, I have some serious questions.
Well, let's back up a little bit then and look at the case that he's relying on is Tefteller. This court has distinguished Tefteller. In the case of Gerald's that we cite, this court distinguishes Tefteller.
But can I just, before we go on, because now you're going back to why HAC applies.
Yes.
But I thought Justice Quince's question was, could the jury have, without HAC, have found one to be get death and the other to get life? And you said yes, they could. But really, the question we'd ask, if an HAC aggravator instruction was given in error as to Mr. Blunt, the issue is whether it's harmless beyond a reasonable doubt. And here there's a much more compelling argument that the only difference in terms of what the jury was instructed on the aggravators was the additional aggravator of HAC. That makes a much stronger argument. It's not an issue as to speculatively whether the jury would have still given death. They might have, but the issue is whether it's harmless beyond a reasonable doubt. And can you say to us that with this circumstance that the jury would have recommended death even if they hadn't been instructed on this aggravator?
I could never tell you what a jury thinks, but let's look at the...
Well, I know that, but the harmless error analysis requires the state to prove beyond a reasonable doubt that an error was harmless. I'm sorry, they require the state to prove that an error is harmless beyond a reasonable doubt. Isn't that the law?
Yes.
Okay, so you're saying you don't know what the jury would do, and therefore, how do you carry your burden if it's error that it is not, that you can say it's harmless beyond a reasonable doubt in this case?
Well, this is an interesting case. And if this court struck the HAC aggravator, you may not be able to do a harmless error analysis under the circumstances of this case. I'm not conceding this is not HAC.
Okay, so why don't we go back
to...
because I think why don't you go back, you were telling Justice Lewis why this is different from the other cases where we haven't found HAC.
Okay, and Tefteller. You look at Tefteller, and that is an anomaly. It has been distinguished many, many times, and this court looks at, in Tefteller, in Gerald's, it specifically distinguished Tefteller because, and we're not saying Tefteller was properly decided, but if you want to distinguish it, Mr. Tefteller was being robbed, he had no money, they shot him. He's down, he's to the hospital. You focus, as the judge did, on what Mr. Blunt went through in the entire episode. They come in, they're shooting. He's sitting there saying, please help me, please don't take me. Keeson says, we're gonna be okay, just give him the money. Keeson's head is shot off in front of Mr. Blunt. Now they're taking all the money. He's still sitting there begging for his life, according to Willie Shelton and what the judge found. And then when they finally leave and they call 911, he's still alive for a half an hour. Now that is clearly distinguishable from Tefteller, if Tefteller was properly decided. Look at the case of Allred that Mr. Quarals was, now when we were up here in Allred happened in the blink of an eye, according to Mr. Quarals. He blasted in the house, Mr. Allred. He sought one victim, quickly killed him, went and got her in the bathroom. It was 1 minute. But the terror that little girl, Tiffany Barwick, went through, hearing him blast in the house and come after her and hear somebody else shot, that's the terror that counts. And that's the same terror that Mr. Blunt went through. Sitting there, watching strippers, all of a sudden they're being assaulted, when they don't give them the money, shooting starts. Willie Shelton was shot, Joshua Daniel, and we know that the defendant shot Joshua Daniel. The defendant was in charge. He called the plan. His girlfriend was the stripper that set it up. He was the one shooting. The 9mm were also shooting. Mr. Blunt is sitting there, and Keeson tries to say, don't worry, we'll be okay. Blunt is sitting there saying, please don't take me, please don't take me. They look at it, they come back, Keeson's head is blown off right in front of Blunt. It's a very small room, they were all sitting there. And then
do you know the dimensions of this room? Do you know the dimensions of the room?
It was very small. The pictures are in the record, and there was pretty much couches everywhere, and with 8 to 10 men and the 3 strippers, it was very tight. They were all sitting right together on the couches. And all this happened right in front of Anthony, who was sitting upright on the couch. Now, some of the people were face down on the floor, but he was sitting upright on the couch. And then to suffer for the 30 minutes, begging for his life. Now, and remember, even when they left, when the robbers left.
I'm sorry, and I may, did you say in this case that he was, there was 30 minutes that they were in the house?
5 to 10 in the house.
So what was the 30 minutes that he's on the couch?
No, 30 minutes between the time that the 911 call came in and he went unconscious when they were putting him in the ambulance.
This really goes back to, I feel like we're going around in a circle, because and tell me what's wrong with this idea that if for some reason one was shot in the head and died immediately, the other is shot in the chest, still the intent to kill, not torture or even think about torturing, but for some reason where the bullet goes, they bleed to death, but the nature of and then they leave. Why? I don't understand how one becomes HAC and the other doesn't, unless there are things that happen before that show that they were there and doing something that sets this apart because of HAC from the norm of murders. As I said, I agree with you that it's set apart because there's 2 deaths. It's set apart because there's a great risk of harm. It's set apart because there's a robbery. And all of those in a situation where you didn't have this other issue with the other victim would qualify this for a death case. But in our system, it's the jury that makes the first decision and as to whether it's life or death, and they weigh the mitigation, which, I don't know if it was substantial or not. They must have thought it was substantial enough in the case of for Evans to impose life. So that's where I'm having my problem. You're sort of saying that we're going to take shooting deaths, and again, if somebody shot in the head, that's one thing, but if they're shot in the head, but they then start to linger because they missed it by an inch, that's going to be HAC. And I don't know how, going back to what Judge Lewis says, I don't know how we go there unless we just want to say we're just going to make all these cases death cases and, let the U.S. Supreme Court worry about it.
And you're looking at it from the shooter side. If I shoot good, it's not HAC. If I shoot bad, it is HAC.
But it did start, I understand that we've said it's not the intent, but it's sort of like one of those issues about whether things are, punitive damages versus whatever, that you start out and the sort of the thing is if you have that AK-47, you're going to be able to kill somebody, and that you're not intending, nor are you engaging in something that's unnecessarily torturous. This thing started out with that in mind. You go back to Dixon, and there's just no question about it. So we go from Dixon, and now we're going to get shooting deaths, depend on whether it's HAC, whether they linger or not. I'm concerned that is going to broaden this to almost all shooting deaths.
Aren't you really saying that it's the amount of torture that a victim experiences during their death? That's what constitutes HAC?
This court has always said mental anguish, knowledge of impending death, and the events surrounding them. That is HAC.
And the distinction is that Blunt had that more than enough here, but Evans did not.
Yes.
That's where we're at.
And that's why the state did not seek HAC on Evans. I mean, if you're concerned about shooting deaths being HAC, Farina was a shooting death. But that little girl saw other people shot in front of her, just like Anthony Blunt. You look at Lynch, Richard Lynch, the little girl that saw her mom shot in front of her, and then she was killed immediately. But that's, and they were shot indiscriminately, that's conscienceless and pitiless to let people sit there and suffer.
Were there any people in the house other than the girls that were not shot? Were there other men in the house who were not shot at this incident?
Yes, there were 8 to 10 men in the house. 2 died, 2 were in the hospital. The 2 that were in the hospital, one was in for 2 years, one they didn't think was going to make it, but he did. That was Joshua Daniel. So there were some of the men who were not injured, and neither were the strippers. I would just like to point out one thing on proportionality. The judge's order, what Mr. Quarals characterized as very strong mitigation. Please review the judge's order on mitigation. The judge did discredit a lot of that mitigation because of contradictory facts. The facts, pages 13, on substantially impairment, the judge found that because the defendant was denying involvement to the very end, it was very difficult to assess the facts and how his mental state was. He gave that some weight. As far as the other circumstances, minimal weight or some weight, the judge found page 15, there was contradictory evidence, 17 contradictions on abuse, defendant denied any abuse, and then the second doctor, Dr. Scott at the Spencer hearing said there was, Dr. Mings at the penalty phase said there wasn't.
How old was this defendant?
22.
And what was this evidence you said about did you say anything about he had a 76 IQ, but there's also evidence he changed schools 10 times because he couldn't be controlled, 4th grade found to be educable, mentally handicapped, in the 5th grade, wet himself and fell down. Was that the nature of the mitigation presented in this case?
Yes, and also, but you have to look at the judge's order because there was a contradiction between Dr. Ming said educable, mentally handicapped, but there was evidence it was learning disabled. His verbal IQ was 73, his performance 83. The judge found that...
How far did he go in school?
11th grade. The judge found on page 22 that these mental defects apparently did not inhibit his ability to plan this event, execute this event, and get away with quite a deal of money. Also on page 22, discredited the drug and alcohol abuse because there was no evidence that there was any drug or alcohol abuse before, during the murder. So I'd ask this court to affirm the conviction and sentence. Thank you.
The state's expert, Dr. Ward, in rebuttal, he opined that he was in the borderline range rather than mentally retarded, but there was a problem with records missing. He said with the hypo of a student in one category, scores 76 IQ, he couldn't rule out. He would assume that he was not mentally retarded. Would not assume he was mentally retarded. Rather, he believed further investigation was necessary. This was pure chaos. Angel, the lights were shot out immediately when they entered. We don't know what Anthony Blunt saw. We don't know what there was some light from a window, the kitchen window. He gets shot. We don't know, and he's saying, "Help me, please help me." And the please don't take me is clearly from the record, in context, he's talking about, Lord God, don't take me now. I don't want to die.
A question on these two victims, and it goes back to what Justice Quince was asking. If these cases had been tried separately, and he had gotten life for the murder of Evans, you would then have the Evans murder as aggravating the Blunt murder.
Well, you have that here too.
Well, so my question is, why isn't it logical that the jury, in terms of deciding life or death, might say, well, he gets life for killing one person, but for the second person, that's now, in other words, it doesn't aggravate both, or it might, but you've got a second murder, and that is a reason why the death penalty, we're going to recommend imposing the death penalty for the second murder.
Perhaps, but I think we would be completely speculating. I think the state just admitted that they cannot prove that this was harmless error, if it is error, that it was harmless beyond reasonable doubt. I think they admitted that during their presentation. On the guns, Angel, the star witness for the state, at volume 11, 1195 through 97, she says that my client and Shushu had large guns similar to AK-47s. So she testified there were two guns. We don't know what Mr. Blunt saw. The lights get shot out immediately, and we don't know that he necessarily even knew that Keeson Evans got shot in the head. He's over there, wounded, saying, "Please help me, help me." He's begging for help. He's not begging for his life. That's an important distinction.
And you're out of time.
Okay, thank you.
Thank you very much to both of you for your argument. The court is going to take its morning recess of 10 minutes before it calls the next case. Thank you.
Rise. Please rise. Florida Supreme Court is again in session. Please be seated.
The next case on the calendar is William Michael Copsho versus the state of Florida. The party's ready? All right, you may proceed. And again, I want to announce that Chief Justice Kennedy was unable to be here today, but he will be watching the oral argument and participating in the deliberations. Thank you.
Thank you, Your Honor, and good morning. May it please the court. My name is George Burton. I'm here for Mr. Copsho. We're back again. Mr. Copsho was here once before, and his case was reversed on a jury selection issue. We're here again. And like the first case, there was a variety of things that the prosecution did in this case that would make an ordinarily easy case a difficult case. And I have a litany of things I want to explain to support that, because really this was a domestic killing with a very weighty prior violent felony aggravator. That's essentially what this case was. And
well, it's with a heightened premeditation, that is the CCP, and he announced 3 days before the actual murder that he was going to kill his wife. So it is hardly, we don't have a domestic violence exception, but it's hardly one of these things where somebody comes in, sees their spouse with another person and loses it.
Well, in this particular case, Mr. Copsho was diagnosed with that he was mentally ill, that he had a personality disorder called dependent personality disorder. And his actions, his whole adult life, was that if a person, and he was married several times and had girlfriends, and the act of violence.
That's sort of an understatement, isn't it?
Yes. Yes, the prior violent felony was consistent with this disorder. It was all over this case. This was not a person who was not suffering from mental illness that had the time to really formulate and ponder his actions, and the judge found that he suffered from this disorder. The expert testified that he was suffering from this emotional disorder at the time of the killing.
What is that? I know one of your issues has to do with prosecutors prosecution used his own extramarital relationship. So how does all this play into it? I mean, he gets so inflamed because his estranged wife is having had some kind of relationship, yet on the other hand, he's out there having. How does that all play into case?
It plays right into my theme here. In this particular case, in the first trial, they wanted to introduce what he did weeks before this murder, which was identical to the Helen Little crime.
Okay, so now let's make sure we're now going to, because you probably didn't say, you said the prosecutor did a lot, but you want to go to your first point, that your view is that the kidnapping 2 weeks before should not have been admitted.
Well, the judge said in the first trial.
That's your first point?
Yeah, said it was 403, that its prejudice outweighed its value.
Did it come in, or was it offered attempt to be offered in the first trial and the second trial as similar fact evidence under Williams?
Both times, yes.
And was it the same judge?
Yes, I believe so.
And in one time the judge says, no, it's not coming in. And what changed? What was the judge's evaluation in this case of that?
He heard the first trial, and the attorneys were the same. Well, the defense attorney was the same. In the first trial, he argued that there was all these indices of CCP that is replete in this record. There's no question that he had a plan, that he said what his plan was, but the murder didn't happen according to the plan. And what in fact happened, and in his confession said he could have been talked out of it. And
but the murder happened according to his plan only because she tried to get away.
Which is exactly, with his mental illness, is the worst thing she could have done.
Oh, and she's supposed to know that?
No, but you're supposed to weigh these things. And when you weigh the CCP, you give it a lot less weight in this case, if you're going to find it, because of the mental illness of Mr. Copsho. That's what.
Okay, but I think now you're floating again on which.
Right.
Let's stay with the point of whether the trial court erred in allowing in the kidnapping that occurred 2 weeks. It occurred before he found out about the affair. So is that correct?
Yes, the defense attorney Miller argued in the first trial that he was doing a frenzied act when he killed her, to the point that it wasn't even first-degree murder. All right? It totally took away premeditation. That's what he argued in the first trial. So this judge said, well, premeditation is an issue. He learned that from the first trial, that this is what the defense is going to do, therefore I'm going to allow it. Well, premeditation was an issue in the first trial too, but he said the prejudice outweighed that value because there's overwhelming evidence of premeditation.
Was there ever a question as to whether that this was being admitted as Williams' rule, where it had to be shown to be substantially similar? Is that, because what I'm having trouble with is, it doesn't seem like it would be Williams' rule as far as substantial similarity, but was the alternative argument that it should come in as to show the nature of the relationship between the two of them in a short time prior to the murder? Was that an alternative argument made?
The ruling was made to show, to support premeditation. That's why the judge.
No, I understand, but there's two ways something comes in under the prior acts. One is similar fact evidence is put in to show absence of mistake or those types of things, identity. They obviously didn't have identity here. It also sometimes comes in to show that the nature of the relationship between the two defendants. We have several cases where you see that the nature of the relationship before, so whether it was a friendly relationship for weeks or it was a relationship where the person was terrorized, it seems to me that is another basis to allowing this evidence in. I'm asking you, was that an alternative basis that the judge ruled in this case it could come in, not as straight Williams rule, but as evidence that it wasn't like this lovey-dovey relationship and then he sets out to kill her. It's that he was terrorizing her in even in the weeks before.
That was not presented that way to the judge.
But
for
isn't
purpose.
that, I mean, what's wrong with that argument? And the judge did leave out what was the most harmful part of it, presumably the rape. So the judge made sure that this was, not that the real inflammatory details were excluded.
He did do that. The evidence has to go to an issue that's in dispute. There was no issue in dispute as to what that evidence was presented for. That's the point.
What
None
was
of
the
that in dispute.
instruction that the jury was given when this evidence came in? Were they given
They were given a
Williams?
Williams rule instruction after it came in because of the objection.
So, and again, was the argument made by the defense in this case that it's not Williams rule because it's not substantially similar to the crime in question?
I believe he argued prejudice because that was
So
the
is
ruling
it
of the...
conceded that it, because to me, I don't see how it satisfies the similarity requirement.
I agree wholeheartedly.
But if the lawyer didn't make that argument, I don't know how we consider that for a basis for reversal.
Well, you can do so on the prejudice that it made in this case, because the reason the state introduced it was not in dispute, and it was inflammatory to put a certain light on Mr. Copsho that wasn't appropriate.
What light was put on that wasn't already?
When you look at prejudice in 403 and inflammatory things, what is the nature upon which the jury is going to act with that information? That is always the question.
Yeah, but what add this is a case. The defendant confessed twice. There's no doubt about the fact. So what in the world? Prejudice, this evidence, then that would push this case, what was already presented.
This incident alone is not enough. I will concede that. But when you add what happened in the penalty phase with the introduction of the incident with his girlfriend, which he did 10 years in prison for, that, I submit, is what put it over the edge. And I'll explain why.
Well, wait.
Yes.
Now, the incident with the prior violent felony didn't come in the guilt phase.
Correct.
All right, so I think let's just stay with Justice Quince is asking you, why wouldn't this, if it was error to admit the kidnapping, why in the guilt phase, wasn't it, let me finish the question, wasn't it harmless error to considering everything else that he had confessed to the murder, planned it, everything else? How does that change the evaluation by the jury in any way?
I don't think that it requires this court to give Mr. Copsho a new trial, but I think it tainted them in a carryover to the penalty phase.
Okay, so now you're saying it isn't a guilt phase issue, so you now go on to the penalty.
Correct.
Okay, thank you
I concede that.
for your candor on that.
Yes, I concede that. In the penalty phase, the old chief stuff and the Brown case, this court made it very clear, and I think it's important, that you have to be able to weigh the prior violent felony. You can't
This
have...
goes, I'm sorry, this particular aspect of it.
This goes to the prior violent felony issue.
All right.
I think that this court, when it initially came out with its determination, you try to strike a balance, because the jury needs to know about this prior violent felony to properly weigh it. They need to know about it. They just can't have a sterile piece of paper saying sexual battery 15 years ago. That's not fair to the state. They need to know. But it is very, very, very prejudicial evidence if it's not handled correctly. What the jury should know is, what were the actions of Mr. Copsho? That's what they should know. But for example, in the Cox decision, this court explained why 5 witnesses testifying to 3 prior distinct felonies of Mr. Cox was allowed in the penalty phase. And this court said, because the sentencing statute for penalty phase says that you should know about the prior circumstances of the crime and the character of the defendant. I don't know what that means when you say the character of the defendant, because, I mean, does that mean he's a liar too? We can bring that in. They need to know he's a liar or he's a thief. I thought that was a misprint every time I read it. I don't know why that language.
Well, the character of the defendant goes to mitigation.
Well, you see, but in the decision of Cox, it says we're allowing these witnesses to talk about the crime because they need to know about his character. It specifically says that in Cox.
Character. Well, I understand
it does.
what you're saying. I'm still at a loss as to how prior violent Williams rule evidence pushed this over even.
Because it shows bad character of Mr. Copsho. And then in the penalty phase.
But you know, what's interesting to me is this is all about the same. The Williams rule evidence about his prior dealings with her a couple of weeks back.
Correct.
So wasn't all of that relevant as a part of the whole way he was dealing with her?
Because if he had learned about her infidelity that put him over the edge, and that was the first thing he did in response, and then he murdered her 2 weeks ago, I would totally agree with you. But he didn't know about that at the time. What he did was he saw her out in a nightclub with a girlfriend, and just like Helen Little, he couldn't have her, and he was gonna have her. He's mentally ill. That's what he did. He did exactly the same thing. He broke in the middle of the night, he assaulted her, he took her away, choked her. He's mentally ill. That's what it is.
You're saying it doesn't go to the premeditation for this crime, but let's. I feel like you've already conceded though for the guilt phase that it's harmless. Now, in the penalty phase, let's talk about the Helen Little prior murder. Where did the state go over the top in putting on the victim to talk about the details of the prior violent felony?
In this point exactly, where they, as bad as this crime was, and it's a weighty aggravator because of what the state presented about his actions, they were horrific. The way he assaulted her, the way he bloodied her,
I agree
that
with
should all come in.
It should come in, okay.
But not her testimony that I was in fear for my life and I wrote his name with milk on the table because I thought he was going to kill me. That's inflammatory. The pictures of the actual injuries and the bloody toenails, that's inflammatory. Those things.
The pictures of what?
Of her, what he did to her.
Now this is where I can understand you saying that her saying she's in fear for her life, maybe that doesn't need to come in. But to me, when you look at a prior violent felony aggravator, it is important for this court in evaluating the weight to be given that somebody, whether they do it because they're mentally ill or whatever, has committed a prior robbery, a prior murder, versus a prior, something where they assault somebody and there's no injuries. I mean, that's the nature. It's not the character of the defendant. It's what is the nature of that prior violent felony? And you agree with that?
Yes.
Okay, so is it the only part that was error is when the victim talked about her own fear?
That is correct. And actually the gruesome photographs showing the battered and bloodiness that.
But what's wrong? But that shows the nature of the crime. I'm having trouble understanding. Let me finish, because again, this goes as a transcript for those that need to have one. What is wrong with putting in the photograph to show the nature of the crime?
Because the prejudice outweighs its value at this point.
Was the defendant lawyer make that argument as to, did they generally say nothing should come in, or did they try to selectively argue photograph shouldn't come in, or this part of the testimony? How was that presented to the judge?
It was twofold. First, they offered to stipulate.
And you understand that doesn't
Right,
get
I
you where
do.
you want to get.
I do. They first offered to stipulate. When they wouldn't do that, they objected specifically to the photograph being come in as being inflammatory and prejudicial.
All right, well, what about that comment that you just said about her saying she was in fear for her, you know?
Well, I want this court to address this issue in their opinion and give guidance to future litigants to what extent these things can come in, to what are the parameters, because if you look at your decisions, you talk about feature of the penalty phase, you talk about character or nature of the defendant is the reason we're going to allow it, and it doesn't give the kind of guidance that's necessary, so there's not overkill.
All right, well, let's say that you're writing this opinion, the court, and this goes to the next case. Is it your view that the judge doesn't have discretion to allow in a photograph or two to show the prior crime?
It depends how gruesome the photograph is.
Well, but how do you ask us to give guidance, and I appreciate it. And we've said that if gruesome photographs show the nature of the crime, but, you know, if they put in 20 gruesome photographs, you know, maybe that's too much. That is the quintessential place where we give judges discretion to look at the photographs and try to make a decision. So I don't know how I'd like to, if we've said something that says the character of the defendant, maybe that sounds like that might be, as you said, a misstatement. But for this case, we go to, as the judge, what the judge went wrong, you said, in the one photograph, and then you said something about the statement. Was the statement objected to by the victim that you're now referencing?
No, I don't believe so. But you see, when you look at prejudicial evidence versus probative, how did the jury process these gruesome photos? Did they reach the proper decision with them? And I'm suggesting, and in this case is unique, because you have a juror who was interviewed after the trial, and he remembered this victim's name. He remembered what happened, and the pictures, in my opinion, are what made this case have the jury vote for death. Those pictures and all the other things like...
But do you really think that if this prior violent felony had not occurred, they would be arguing to the jury, yes, he planned this murder, but, you know, he was distraught and he really otherwise loved his wife and basically he's a good guy. It changes the, you know, we talk about quality of the aggravators, you know, that it's not a mere weighing. We especially, I take it very seriously on prior violent felony. You know, somebody has committed a murder before, and then and somehow they get out and then they commit another murder. I mean, that's, from my point of view, that's going to be, you know, there's going to be a death penalty that's probably going to be upheld if there's everything else. On the other hand, as I said, if it's the prior violent felony was something where they, you know, hit their brother when they, 4 years before and they got an aggravated battery charge, it's not going to be the same weight. And that's why I'm asking you, I don't see how you can, it's prejudicial, but how do you escape the fact it's prejudicial because it's what this defendant did to this victim?
That's correct, but when the prejudice inflames their decision the wrong way, that's when you have to draw the line, and I think that's what happened in this case. That's what happened, because that's not what evidence is supposed to do.
So if the photograph didn't come in, then her testimony would have been itself, wouldn't it still been pretty inflammatory?
Yes, and I think that the trial judges have to be instructed that in prior violent felonies, they should be only limited to describing what the actions of the person did and not the emotions and harms to the victims and those sorts of things.
All right, well,
and there's no such guidance.
That might be fine, but well, you do know, as a good appellate lawyer, there has to be something called an objection first before the judge can put on notice that that part of the testimony should not come in.
That's correct. I concede that. And you know, I'd like to jump to the way they tried to get HAC in this case, which they didn't in the previous case, because I think it dovetails too. In the first trial, they were not able to, they didn't argue HAC, and they didn't introduce evidence of his wife's suffering before she died. In this case, they did. They argued it to the jury, and I think that was very damaging as well. And they instructed the jury on HAC, and this judge knew this wasn't a HAC case. And this is what I'm saying. It's not one thing. It is it goes on and on. It was not a kidnapping here at all, and they're instructed on felony murder.
I don't know, so why isn't it a kidnapping?
Because for kidnapping to happen, there has to be a forcible abduction or a secret abduction of a person for purposes of committing a crime. Absolutely. Absolutely. But he never got to the law requires that he gets her to a place out of the public where she cannot have any safety.
The
And that
law
didn't happen
requires
here.
that for kidnapping? Where is that in our law of kidnapping?
That was in my reply brief. I specifically mentioned the cases.
Yeah. We have a case where a father picked up his daughter at Publix. Did you cite that case?
No, I don't believe I cited that one.
Picked up his daughter at Publix, and you did it every evening. He was going to take her home. That this time he took her out into the Everglades, and we didn't know whether she was pushed out or jumped out of the vehicle and was killed. And as my recollection, this court held there was no kidnapping, much to my surprise, but I think there's case law like that that's out there.
Right. I didn't see that case. The ones I saw were district court of appeals cases where when you're doing things by stealth or secret, they ultimately have to be transported to a place where they are beyond the purview of the public and so forth, which would have happened in this case if he took her out to the Ocala forest, but he never did. He was right. She jumped out right on a busy highway in front of a lot of people. I think you could make a case for that, perhaps, that there was an attempt. Absolutely. His intent was to take her to a place to be alone to execute her. That was his purpose. That was his plan.
Since we have CCP, we know there's premeditation.
There's no doubt that this was a premeditated murder. It's to what extent his mental illness mitigates that premeditation.
Well, it seemed like she realized that in the car that this was not going to go well. So wouldn't she kidnap at that point for her to have that realization enough that she's trying to jump out of a car doing about 60 miles an hour?
I think that would be the state's argument, Justice Paulson, exactly. But our point it was not substantial enough of a holding, of an abduction at that point, because it was so fast that she never acquiesced to that abduction. She didn't acquiesce at all. It's sort of like Hodari versus California acquiescing to police authority. She never acquiesced to his abduction. The opposite, she fled. So I think you can't say this was an abduction. But I understand your rationale, and I reject it. I think I have my time.
Well, you're in your rebuttal.
I'll stand mute at this point, and thank you so much.
Thank you.
May it please the court, my name is Barbara Davis, and Mr. Burton addressed points 1, 2, and 5. As far as the point 1, the Williams rule part of that during the guilt phase, I agree with Justice Pariente and Justice Quince. The event that took place 12 to 13 days before he murdered Lynn, his wife, was an inseparable act. It showed the entire context of this event and how it the criminal episode took place.
But was that the way it was argued?
It was not.
Okay, so but this thing of it, to put the thing in context is sort of where I was going. But since you have this being that what precipitated the plan to murder her was that she had this one night stand and he got upset with it. And there's no question that it's premeditated CCP. I'm having a hard time understanding under that circumstance where what is it, say it's put in context, sort of a nice broad brush, but we require a little more for prior violent acts. What element of the crime that the state needed to prove does the kidnapping relate to?
the abduction. He was never charged with this. She never reported it. But it shows
No, I said what element of the crime? The crime
shows,
that he was...
It shows premeditation because...
How does something 14
because he
days...
left her alive, and then he found out she had had an affair, and he had threatened her that night. We know in the penalty phase now, Dr. McMahon said he had threatened Lynn, the defendant threatened Lynn, both one prior time and the night he abducted her, I will kill you. And then that was on October 14th. October 24th, one of his friends asked him a hypothetical, what would you do if your old lady left you? He said, I'd kill the effing bitch. And then the next day, he finds out that she had, in fact, had not an affair, but a tryst with one of their friends. And 3 days later, then he kills her. So,
Ms. Davis, the state tried to get this evidence in the first trial, correct?
yes,
As Williams rule evidence, correct?
yes.
The judge decided that the prejudice outweighed the probative value, correct?
Well, he didn't allow it in an abundance of caution, but
I have what, I mean, it sounded to me, anyway, he didn't allow it. Same judge didn't allow it, correct?
I'm not sure about the same judge, but...
The prior judge didn't allow it. The same evidence was
And
not allowed. Is that correct?
That's correct.
I'm just bear with me, okay? Now, this judge hears, and the state tries to put it in as Williams rule evidence. It's not Williams rule evidence. It's not substantially similar. It may be prior bad act that's relevant to an issue, but you got to weigh that carefully against whether it's outweighed by the prejudicial value. Now, what was the jury instructed about how to consider this act, not as evidence of his guilt, but what? What was
First
the
of
jury
all,
instructed?
I don't agree with you that it's not Williams rule evidence. It can be both, and this court has decided cases in which it is both. It is the same victim. He abducted her. He threatened her. He raped her, but the judge left that out. And it is enough similar to this event to qualify for Williams rule. The judge allowed it for premeditation because that was the big issue in the case.
I guess I just don't see how something that is a week and a half before is relevant to the premeditation for this crime. I mean, I can understand that if the crime was planned for months, that this would be one act that, you know, and as part of what he was doing, he was terrorizing her. I can see that. But there's no evidence, I mean, unless, did the state argue that the premeditation for this crime started back 10 days before? Is that how they argued it?
No, but it's relevant to premeditation, intent, and motive because he left her alive. And then he found out she had had this affair, and that's when he decided, I'm not leaving her alive. And he started his planning. So not only does it show the criminal episode, it shows that he started premeditating right at that point.
So did the state in the penalty phase use this for CCP?
The prior
kidnapping? I mean, it would seem to me, if your theory is correct that that's how the state used it, then this would have been argued as part of CCP, that he was starting this 10 days before, and that it was he was part of a continuous plan to first terrorize her and then kill her. No? That wasn't the way it was argued?
No, and the judge's order on CCP was that he started making these statements, that he did make the statement, if you ever leave me, I'll kill you, during that abduction. And then he finds out about the affair, and that's when he started planning
So the judge did use it for CCP?
And you know what, I'm going to have to look at that sentencing order before I say absolutely yes.
But now Mr. Durden says he conceded, which I appreciate the candor. You know what? Even if it came in based on the facts of this murder,
it's harmless.
And I don't know if we ever got to where, how is it not also harmless in the penalty phase? Could you tell me, was that used in the penalty phase? That is, how was the kidnapping used by the state in the penalty phase? this prior incident with his wife.
And that's the question that,
You're not
but
sure.
I've got the court's order right here on CCP.
Well,
and-
even whatever the court said, what I'm asking you really, because we're talking about whether it influenced the jury, how did the state use it during the penalty phase?
I'm not sure that was used at all in the
Well,
penalty
that would be
phase or
important.
argued.
Okay. If
Because-
it was not used, then that would seem to militate against his argument that it crept over into the penalty phase. So maybe you should go to what he's argued extensively, which is this the little prior violent felony, and how has our case law gone awry about what goes in about a prior violent felony and about the character of the defendant. Help us on that.
Well, first of all, on the photographs, as I said in my brief, that was completely abandoned. There was no argument about the photographs. Secondly, this court recently, since Rogers, has issued two opinions. One was Miller, one was Reynolds, Michael Reynolds. Reynolds was the case in which there was a prior assault, a sexual assault. He had not been convicted of it, but the details were relevant to his character. And
Is
same
that the
thing-
first time that we ever said that the details of a prior crime, which didn't result in a felony conviction, can come in for the defendant's character, as opposed to refuting something, that the defense puts on, which is, this is a great guy, and then you impeach him, he's not such a great guy. So does it come in? Can the state put it in if the defendant doesn't argue something in mitigation that would make it relevant to refute a mitigating circumstance?
No, the state is entitled to show the character. This goes all the way back to the Rhodes case that cited.
How is that? What aggravating factor is the bad character of the defendant relevant to in our death penalty scheme?
We're in the prior violent felony. This court has repeatedly said that the state is entitled to show the facts of the prior violent felony so the jury can assess the weight to be given to that.
Oh, I agree with that entirely. I thought you were saying something that there's some other exception, that things come in that the guy is a bad guy to show his character. You're not saying that.
No.
Okay.
Oh, no, I'm just saying that the two cases since Rogers are Reynolds and Miller, in which the prior victim did testify, and this issue was raised about having the victim come in and testify, and that having the real live victim there describing things is more prejudicial than probative.
All right, so we have come out, and I agree with you, that putting the victim on is entirely appropriate. You also agree that we want to make sure the judge exercises some discretion as to how inflammatory it becomes. And you're telling me that the photographs that were originally objected to were not objected to. Were abandoned. Any objection was abandoned?
I'm not sure whether it was objected to or not. There was two sentences in the initial brief that mentioned something about photographs, and it was never developed.
And the idea that she was in fear of her life, her perceptions, was not objected to either. That's what, Mr. Durden seems to agree to that.
I would agree with that, yes.
So the point being that we have a situation here where and this is a friendly question, I don't see if they don't object to where it goes over the top, it's like a lot of this victim impact evidence, someone says, no, none of it should come in, and then it comes in, and they go, oh, now that part shouldn't have come in. We need defendants to tell the trial judge which part is objectionable.
Yes, and it's clearly admissible. The victim clearly can testify. The state clearly can get the details in. And as far as it being a feature of the penalty phase, it was not. There were 8 witnesses from each side. I think I outlined it. Her testimony was exactly what he did. And I'm sorry if they think that that's awful, but that's what he did.
Is there some language, though, where I agree it comes in to explain the nature of the prior violent felony? Because, as I've said, can't be all equal. But have we said, and you're saying it's correct, that those details of the prior violent felony come in to show the character of the defendant?
Exactly what this court has said.
Well, we could have said things, but have we said that for the last 40 years, or is this something that just has come into a case, and maybe it was a mix-up with the character of the prior violent felony?
It says Rhodes is the seminal case.
What year was that?
Well, Rhodes is 1989. Stano, they said it. It says
And
right
character
here,
of the defendant. It says
assist
character of
the jury in evaluating the character of the defendant.
All right, so we didn't go wrong. If it's been incorrectly stated, but everyone understands it's really goes in. It doesn't come in separately for the character of the defendant. It comes in to adequately describe the crime, and so the jury can evaluate the nature of the prior violent felony.
Yes, and in Reynolds, which was a 2006 case, this court said that the testimony merely relayed the actual details surrounding this prior conviction and assisted the jury in evaluating the character of the defendant and the circumstances of the crime so they could make an informed recommendation. And that's citing to Rhodes, which is the 89 case, and that flows through everything. Stano quoted Rhodes, same thing.
Now, you mentioned something, and since I guess we'll have to just look back, could the uncharged kidnapping have come in as a prior violent felony?
Could have, but not necessary.
Was it, and the state didn't try to offer that in this case?
She never reported it. There was no statements from her. That would not be a real prudent thing to do. Since, I mean, they went to the friend's house in the morning, and, I mean, but it would all be hearsay if she never reported it.
So how did the hearsay come in for a crime that was never reported in the guilt phase? I mean, what she said, not what they observed. How did that come in?
Because the defendant went with her. So not only was it Williams wrote, was admissions of the defendant. He admitted going in, to his friends, getting her, and he was going to counseling. Now, by the way, this mental illness that we keep talking about, the judge found that as a non-statutory mitigator and said that this dependent personality disorder did not inhibit his acts in any way and did not affect the crime. So therefore, although it was, he found it as non-statutory mitigation. The exact quotes on page 10, emotional or mental state did not inhibit his ability to act, nor did it inhibit his ability over a 3-day period to concoct an elaborate and comprehensive plan to kill his wife. So if you look at this mental disturbance, it actually non-statutory and got moderate weight. All the other mitigation, little weight. We have 4 very strong aggravating circumstances. I would like to touch on the kidnap.
Well, before you move there,
Yes, sir.
do we know any more detail about his being in a mental hospital 3 times?
In 1982, he had voluntarily checked himself in because he was going through some hard times, which the state actually. He probably. Well, he was married 5 times to younger women, so it could have been one of those. But he clearly knew and knew that he could make that choice when he felt in trouble to check himself in. Additionally, as part of his probation for the Helen Little event, he had done 4 years of counseling and had the tools now and successfully completed it. This is what the state presented in rebuttal. He had these tools. He had that knowledge. He chose not to use them. For 3 days, he made that decision and put together this elaborate plan, stealing a gun and hiding one just like it at his friend's house, contriving a way to get her out of the job. And I would agree with when he got her into that car by a ruse, at that point, it was kidnapping.
Wait, well, let's go into that. Have we not held in a case where a father routinely picked his daughter up at a Publix, that's where she worked, and on the evening he did not take her home but took her out, was heading for the Everglades, and she ended up on the roadway and died? Then didn't we hold that that was not a kidnapping? You're not familiar with a case like that?
I am not familiar with that. It wasn't cited in the brief, but I can tell you...
That case has troubled me, it's haunted me, and I'm going to have to go find then that...
I will, and I shall find that case because, I mean, there could not be evidence. Here we have evidence that he used a ruse to get her in the car, parked behind her car so she'd have to ride with him, used a ruse to
I understand
get her to
the facts of this case. I thought that we had created a problem in that law, so it may be my mistake, but I'll go back and check.
And the other that Justice Polston mentioned, once he pulled that gun, and we had two cars behind her who were eyewitnesses seeing the car swaying, a commotion in the car, and Lynn jump out and start to run. We also have the defendant's confession that he pulled the gun, she tried to struggle with him, he got her by the hair. So it's the state position, when he got her in that car with the intent to terrorize and kill her and take her to the forest and kill her, right there, that's a kidnapping. If anything, you know, last case scenario, when he pulls the gun on her and she's struggling to get out and he's holding on to her hair and not letting her out, and she's jumping from a car that's going 60 miles an hour, clearly a kidnapping. I think those were all the issues that, on the kidnap, I would like to point the court to the Richard Lynch case. That was the little girl that he lured into the house under false pretenses. Now, I would love to be able to talk about the cross appeal. As you know, the issue that I'd like to talk about is that the prosecutor asked the mental health expert questions about what the defendant had told her. She refused to answer it. She refused to give up her notes. The judge allowed her to do that. This court recently decided a case, Dane Patrick Abdul, that said that under the discovery rules, that type of information, reports, raw test data, needs to be presented to the state under the discovery rules. The defense had argued. Sometimes they don't do reports, but basically what the prosecutor wanted to be able to cross-examine her on the defendant's statements. She had defendant's statements, and she could filter them. They did a deposition, and that's where she refused to answer the questions and refused to be cross-examined on anything the defendant told her. And that's when the prosecutor went and asked the judge to compel her to answer those questions and give him the notes. And the judge would not allow that. Now, in Abdul, the raw data, which is the notes of the testing data, this court said under the rules of discovery, that is discoverable. And I think that's just like the, so we have and in Francis, you held that the mental health expert can't just get up and start parroting whatever they want. The defendant said this and not be subject to cross-examination. In Blackwood, Hitchcock, and Francis, this court reiterated that when there is hearsay at the penalty phase, the other party has to have, well, the statute says the defendant has to have an ability to rebut it, but this court has made clear that that includes the state. So when the state cannot rebut that hearsay testimony, a mental health expert could get up and just say, oh, according to the defendant, he did this, this, and this. And if we cannot cross-examine that, have the notes of the interview, then that violates the statute. It violates Rule 3.220, Rule of Discovery. And I'd ask the court to look at this case and rule that once that defendant elects under 3.202 and the state has properly filed their notice of intent to seek the death penalty and our mental health examiner has a right to examine them, that does not, as they argued in Abdul, override the state's ability to get that raw data and notes.
Because I thought the trial judge said something about the length of the deposition and that questions were answered, but I'm not completely clear on that.
He just said, you did a deposition, it was 80 some odd pages long, that's fine. And while we're speaking of the trial judge, I did want to touch on the heinous atrocious.
Before you do,
Yes.
before you do that, so are you asking the court to adopt a blanket rule that any time a mental health expert testifies that all of their entire file is subject to discovery, or is there any discretion for the trial judge?
If there were communications between a lawyer and his mental health expert, that would be protected. However, when there are notes, raw test data, the actual scoring sheets of the data, because, I mean, and this has never really been an issue until recently, because they usually give that up.
But and you're saying under our rules, and I did think, frankly, that the notes would be part of what would be produced, as well as the report. Certainly the notes, as you say, are the kind of, quote, best evidence of what was said, and if the notes are kept. So it wouldn't be then a discretionary issue as to what the notes that were done in the course of the evaluation between the defendant and the mental health expert. It would be a rule of law for clarifying our discovery rules. Do we need to do that? I mean,
Well, it's just like Abdul, where they had argued that 3.202 supersedes the discovery rules. It doesn't. When you have an expert, you need to provide the state with the reports, the raw data, everything.
so it's just really clarifying that Abdul and the rule require that to be produced.
Yes, yes. And I want to touch on my other cross-appeal issue. The trial judge made an error of law in rejecting heinous atrocious. He said at page 4 of his report that the evidence does not establish the defendant deliberately and intentionally inflicted mental or physical suffering. So he was focusing, consequently, I'm not finding HAC.
So if this case hung on HAC, which it doesn't, but you would ask us to correct that misstatement because there's not a intent requirement. It includes recklessness, correct?
Yes. And he said, the judge says, well, he intended to end her life with the first shot. However, unfortunately, he terrorized her for a long period of time, holding her in that car. She was running. He chased her down. He shot her through the chest, shattered the humerus, excruciating pain.
So are you saying that if the judge had stated the correct law, there would be no discretion under this set of facts in rejecting HAC, that it had to be found as a matter of law?
No, he would still have the discretion to find it, but he erred as a matter of law in saying, although these facts are very egregious, the defendant didn't mean. He just was going to kill her with the first shot.
Well, but that a little bit goes, because this is different than the case before, as to it's not their intent at the time, but if they come in intending to shoot somebody and assume it's a quick death, then it's a question of the circumstance afterwards may vary. I think this one, frankly, is different in terms of better for the state than prior case, because she's running away and he's continuing. But it's really, these cases become again, I get very concerned where our line is. So again, if you would ask us, assuming that HAC, we don't get to that, but that we would correct that statement that it's not just the intent, it is whether something's reckless or pitiless, those kinds of things.
And actually, I'm saying the trial judge should have found heinous atrocious.
But you can't say that. You can't say, unless we're going to say as a matter of law, aggravators have to be found, that the judge under these facts has to find HAC. I mean, you surely can't.
No, I'm saying that had he understood the law, under these facts, and this court can do a de novo review since there was a misunderstanding of law. And we know from the penalty phase now, Dr. McMahon did say that she, and although there was no HAC in the first trial, there was a second witness.
I'm not sure I understand why the state in the year 2011, when you've got a case that has all these other aggravators, which is CCP, the prior violent felony, the kidnapping, that why we're, you know, when we talked about HAC being one of the most weightiest of aggravators, just don't understand if the state really wants to try to take a position and try to have HAC found in shooting deaths, where that benefits, where we go with our death penalty law to do that, Ms. Davis.
Well, you've
it's
got
not
to understand,
necessary in this case.
these cases are winnowed and winnowed and winnowed. We assume the prosecutors only try the cases that are death cases.
Who
we
assumes
assume
that?
the
Who assumes that?
Well, that's what the case law assumes, because that's their job to decide if it's a
And
death
that's
case
why,
or not a death
would
case.
you want to compare whether cases that are prosecuted as death penalty cases in Jacksonville would also be prosecuted as death penalty cases in Dade County? I mean, you don't want to go there, really, do you, as to whether the prosecutors only prosecute cases that are death penalty cases? Really want to go to that?
Well, I would certainly hope so, because otherwise, ethically, the state would have
Well, they don't
a
have to
large
charge
problem.
aggravators in the indictment, and
And
we've
we
said
would-
that. And so why? What I'm asking
We
you in this
would as-
case, why do we not assume that the reason that the prosecutor sought the death penalty was because this man had a serious prior violent felony, that he planned this over a course of several days, so there was CCP, that he kidnapped his own wife? I mean, why do we assume that, oh no, it's because of HAC? If it hadn't been for HAC, they wouldn't have prosecuted
I'm not
it.
saying that at all, but the rest of my sentence is, when the state seeks the death penalty, it's because it is a death case, and the state is entitled to have the law applied equally in all cases. This judge made an error of law. Under these facts, this case was heinous, atrocious, except for that judge making an error of law. It was a blatant error of law.
Well, we get into a situation, it seems, that maybe there's misstatement with regard to it. But when we strike an aggravator, we're holding as a matter of law that evidence does not meet that standard. Do we have a case that says that if such and such meets the standard of HAC or whatever, that we're going to reverse the trial judge, the reverse of matter of law can't find it, as opposed to matter of law shall find it? Do we have a case that says you shall find any particular mitigator?
Aggravator.
That's what I mean, aggravator, I'm sorry.
Basically, this court does not rule on the additional aggravators. I have raised clear errors of law before. I raised it in the Bouzia case.
Okay.
But
Have we held? It's a simple question. We have not, have we?
This court normally does not, but the state is asking this court to, as a matter of law, correct this mistake, because, as you said, through the complete litigation of this death penalty case, the law can change, things can happen. If there were an aggravator stricken at some point in time, we are entitled to have the law properly applied, just like the defendant does. And
Well, I
this
mean,
was,
no, the point would be is that was a misstatement of law. We'd have to send it back for a new trial to determine with the correct law what would happen, wouldn't we? We can't just haul off and say on an aggravating circumstance that we would say, okay, this applies as a matter of law.
This is a cross-appeal issue that
Oh, no, I
the trial
understand, but I'm
judge...
saying, if you're correct, what do you suggest is the remedy?
that you correct it on
Just a
cross-appeal.
statement of law, but we don't hold that the aggravator applies as a matter of law.
He basically says that...
Just please, come on. I understand your point.
Yes.
You're not willing to go, are you? That's what you want this court to do, is to say, as a matter of law, HAC applies in this case.
Yes.
That's what you're asking. Okay.
All right, I think,
And I
with
think
that,
this
if you
court
wanna
has the
just-
authority to do that.
Okay, and if you, with that, you are out of time if you want to make a concluding statement.
I'd ask the court to affirm the conviction and sentence.
Thank you, Ms. Davis. Durden, a rebuttal?
Thank you. One point I want to make of correction.
Burden, I'm sorry. Exactly.
Yes,
I'm sorry.
That's fine. Mrs. Davis claimed that at the time he did the kidnapping of his wife, that he said that if she left her, he would kill her. That's not what is in the record. What's in the record is after that incident where he told his friends he was going to get help, days later he was having a beer with Mr. Cameron, and he said that to her, you know, if she leaves me, I'm going to kill her.
And you're not objecting to that statement?
Well, in the brief, we said it was prejudicial for that to do as part of that.
But you haven't argued that today. That's a different statement.
It's another statement.
How was the, let's assume that there was error in admitting it. I don't think you ever got a chance to argue how it would be not harmless beyond a reasonable doubt in the penalty phase.
It's in this, my theme is it's all cumulative. I didn't get to them all, but you have that guilt phase, prior bad act. You have the penalty phase going overboard in a prior violent felony. You have kidnapping improperly found. You have HAC being argued, the suffering of his wife at the time of her death that didn't come in the first trial, came in the second. You had the state arguing HAC to this jury where it should never have had. You had victim impact evidence, which is, I submit, never proper, but it is. But in this case, they went to say that they're haunted by the way she died. That's how, you know, that's not proper. These kinds of things. And then you have, in this case, which I've never seen before, you have a juror being interviewed after the case and saying that the state did a great job proving guilt, and we had no trouble arriving at a guilty verdict in this case. The penalty phase was a different matter. He said it was very, very heated, and he described why people voted for life, but that wasn't in the article. We don't know why they did, the ones that voted for life. But the ones that voted for death did so because of what happened to Helen Little. That's why they did it. We know, and we never know in these kinds of cases how this impacts. Here we do know.
Well, why is that wrong? In other words, if the nature of the prior violent felony is at issue, that somebody who has done something like that before, and then he gets counseling, he just disregards what he knows, and he goes, not this time just to, you know, kidnap, but to kill. I just help, because again, as I've said, I've always thought that the nature of those prior violent felonies were very important in deciding whether a case should be a death penalty case. More so than whether someone shoots somebody or strangles them, you know, to decide whether someone lives or dies. There's people that have disregarded the law in a way to cause violence, terrible violence, life scars for a woman, is not relevant to whether that person should get the death penalty.
It is relevant, and in fact, you've made that case emphatically over the years, that very point. And I'm simply saying there has to be a limit so that they properly channel that information correctly to derive the correct decision. If it's too much, it inflames their passions.
But do you agree with Ms. Davis now that, and this is not your problem, but that the parts where it got to be too much were not objected to as too much?
Some of it, correct, yes, but the picture was objected to.
We'll have to look and see about that.
Yeah, yes, it was.
Were there several pictures offered and the judge only let some in, or how did that go?
In my memory, I think he may have left some out, but I'm not certain.
And would that be important in evaluating whether the judge abused his discretion?
Yes, of course it would be.
Now on HA, do you have a few seconds left? What's your, is there anyone
on HAC,
on HAC?
your argument with Mr. Hall previously, this court spelled out perfectly the problem with HAC and channeling and how the states are going with HAC, in that it used to be, what was the perpetrator trying to do? The court primarily focused on that and not victim lingering and so forth. But I would submit to this court that if a victim lingers and there's torture to that person while they linger by the person, I think that's what makes lingering important when they affect a way that ordinarily would be a swift and...
From the other people who were at the scene? Because I thought there was some indication in this record, and you can correct me if I'm wrong, that he was keeping people at bay from coming to the victim's aid because he wanted her to in fact die. So even under, if that is the case, then either under your scenario, we not only have the suffering of the victim, but the defendant's indifference to that and wanting that to happen.
There was the things he said right on the 911 call. It's in dispute. It's not disputable as to what he said at the time. It was right on the 911 call that was recorded and presented to the jury. But he did not want her to suffer. He specifically, in his confession, said he didn't want her to suffer. That's why he shot her more than once, because he didn't want her to suffer. He saw that the first shot didn't do it, so it went boom, boom, right in the heart.
You are out of your time. Do you want to conclude with a statement?
I would just conclude that this is a kind of case that, had it been presented properly by the state and not so aggressively with the bad acts and the additional aggravators and so forth, this court would have an easy decision. But I think this case, they're going too far, and it's because their efforts aren't being channeled to what they have to stick to get a proper conviction for first-degree murder.
Thank you very much. Thank you to both sides for your advocacy. We'll call the last case of this morning, which is Samples versus Florida Birth-Related Neurological Injury Compensation Association. Are the parties ready? You may proceed.
My name is Mayanne Dowd, and I'm very pleased and honored to be before this court on behalf of our clients, Angela Samples and Kenneth Samples. And as this court knows, their daughter Mackenzie Samples was born in August of 2007. And during the labor and delivery, she suffered severe brain damages as a result of a lack of oxygen. Her parents filed for a petition for benefits under the Neurological Related Injury Compensation Act. And after an investigation and determination that this child and the circumstances under which her injury occurred qualified under the act, both the Samples and NICA filed a joint petition for benefits. Yes, Justice Quince.
What is the purpose of the portion of the statute that allows the $100,000? Is the purpose to help assist with taking care of the child? Or is the purpose to more in the nature of a lack of consortium that we have in some of these other cases?
Right, a filial consortium claim. And as you well know, that has been one of the factors that the 5th District, the lower tribunal, looked at. And we submit, Justice Quince, that this is not an economic compensation claim. And the reason we say that is the NICA itself sets forth in great detail a number of economic compensation claims to which the parties can file a petition. And in fact, those economic claims range from products and supplies that are available to adult surviving children, through renovation of a home, and in fact, through direct compensation the parents can apply for if they in fact provide some of the care themselves. So there's a wide and detailed range of economic claims that this act provides.
And the way it provides it is it doesn't give it a lump sum. Is that correct?
Exactly, Justice Perry.
As it's incurred.
That's right. Great detail sets forth the circumstances under which a parent can apply for those claims. And in fact, we would also suggest 2 other factors that underscore our belief that in fact this is a replacement for a filial consortium claim. One is that in another part of the act itself characterizes these damages as non-economic damages. There's a section of the act where as an early part of the stage, the parties are required, and NICA is required to estimate what the total claim will be. And in that, the statute actually says, estimate the parental award, the non-economic damages award at the maximum for purposes of determining the estimate.
That's actually in the Act itself, as
Yes, it
opposed
is,
to
Justice
NICA
Periente.
rules?
It is in the Act, and I have the number here, and I will give it to you.
It's there.
It's 766-3149A.
Now, why is it important to your argument on equal protection and any other of the issues that this is, that this appears to be non-economic damages? I mean, to me, for all the reasons you've said and more, why is it important for your argument that it be characterized as non-economic consortium damages as opposed to economic
Well, a
damages?
couple of reasons, and if I just may go back and make one quick point. We filed in the record 2 of the cases in which the administrative law judge actually characterized these this $100,000 award as a
Well, I
filial
don't think that
consortium
would
claim.
really be
It's certainly not dispositive by any event, but I think it does lend some flavor to the, some would say, obvious characterization of this. And the difference, of course, that it makes in part is that one of the things we have to do is measure the adequacy of the remedy, the commensurate nature of the claim these parents are left with when we take away their right to file a claim at the common law. And we're not here to say that the child doesn't receive adequate compensation. In fact, many have noted that the availability of the remedy to the child, as we've just talked about in another context, is fulsome. There's a great benefit that the child does receive, and if you do that commensurate weighing, the child receives it.
Is the child awarded non-economic damages?
No.
So the
Justice
only,
Brandt.
who else, where
The parental award that we're talking about, the one at issue, is the only non-economic damage award available to the parents. And the reason that's important is, think of the common law claim they have. This is an eclipsing, comprehensive, and life-changing injury to a child, and thus to the parent, who will never be able to enjoy the kind of life and relationship and consortium with that severely injured child.
But you're saying,
that
but
they otherwise
on the
would have
other
had.
hand, you're not, I mean, how could, especially for the mother who gives birth to this brain-damaged and profoundly brain-damaged child, how could $100,000, whether it's split between a mother and a father, or, there's no way to measure that. I mean, how do we say, 100,000 is an arbitrary number.
For a mother and a father, certainly we all bring our own filter to the things that we see, and
Well, I
as
don't
a
think we
mother,
need to have been, I mean,
it's incomprehensible.
So, but you don't make an argument that if you gave 100 to the mother, 100 to the father, then the act would be perfectly fine. So
We certainly do not, but what we do say is that from several different points of view, if this court, for the many reasons available to it, chooses to interpret and construe this statute to cure these constitutional infirmities, and we submit there are several, not just the equal protection one that was certified by the 5th DCA, but if this court chooses to rectify these constitutional infirmity problems by applying this $100,000 cap to each parent, rather than seeing them collectively as a single entity, when in real life they are not a single entity. Angela Samples, the claimant in this case, were she a single parent with no father on the scene, which unfortunately happens, would receive double her claim
we're
for
talking
no
about,
reason.
again, it does seem, I mean, the way I see this, frankly, is that I see it that it's non-economic damages. I think they'd be hard-pressed to say they're economic damages, if Fifth District did. But the question is, let's go first, let's assume then it's non-economic damages. Do you think that the statute allows for an interpretation like it was interpreted in St. Mary, a different statute, to say the legislature intended for there to be separate awards for the mother, the father, or or is the Fifth District correct that it plainly only allows for one award of $100,000?
Well, we suggest that, in fact, irrespective of the legislative analysis to which NICA points, if you look at the plain language of the statute, which of course is the pole star for interpretation and intent, the language itself can just as easily be interpreted, putting aside the other constitutional infirmities, just as easily interpreted to mean $100,000 to each claimant. And of course, this could have been cured by saying any number of things. We could all come up with hypothetical wording that would have made this crystal clear, but we submit, even if the language were crystal clear, then if you solve that limited problem, that is the ambiguity that is there, then you run into other problems as well, because we have the equal protection problem.
Well, let's stick with the plain language. Is it required they jointly file a claim on behalf of their child? Is that how that goes, or does one parent file the claim?
Actually, the parents themselves may have a dispute about the amount. And there have been some limited circumstances.
I'm talking about for their child. Who
yes,
files that claim?
Either a claimant or two claimants can file on behalf of the child.
And then is there, when the parents, and they could be estranged or never have been married, they each, in this case and in other, file individually a claim?
In this case, there was a joint petition filed by Angela and Kenneth and NICA for benefits. So
it was, but it doesn't make, but it says, but a claimant, if there was a mother who was not living with the father, the mother and the father, there's no question that NICA would accept claims that a father who was not living with the mother would have a right to make a claim.
Practice has been.
I mean, does the father who is not unmarried father, not living with the mother, have a right to make a claim under NICA?
Yes, the language says that upon determining that an infant has sustained the injury and the other factors are also satisfied under the Act, the administrative law judge shall make an award providing compensation for the following items, and then they're set out, as we said, in detail. And when you get to the part at issue here today, it says periodic payments of an award to the parents or legal guardians of an infant found to have sustained a birth-related neurological injury, which award shall not exceed $100,000. That language could say in total, or to both parents. As I said, we could all come up with hypothetical language that would cure that. What we submit is certainly sufficient ambiguity to allow this court to construe it in a way to avoid all these problems and put the question to rest.
The fact is that the language actually says parents in the plural as opposed to parent. And so I'm just wondering if doesn't that language, in fact, suggest, it says parents and it says guardians, both in the plural, that this $100,000 is for the plural parents and for the plural guardians?
Well, I certainly understand, and in fact, that single S, as opposed to the lack of the S in the word award elsewhere, is we would submit, fairly thin reed upon which the 5th District reached the conclusion you were just suggesting in your question. But respectfully, even if that's not an ambiguity, and even if we say we'll take our cue and our clue from that single use of a word S, it doesn't solve our equal protection problem under St. Mary's. It doesn't solve the problem that the ALJ is given no guidance at all to decide how to divide this number. In other words, if you say, look, it's $100,000 no matter what, how does the ALJ decide between a parent and a guardian? How about between two parents and a guardian?
And that one I think is the weakest of your arguments, because juries all the time are required to assess the relative consortium claims, and then if there's limited insurance, it's just done in proportion to what you evaluate the claim. So,
right, but
that's how you would argue.
We give them guidance to do that. We, first of all, for example, characterize it as a consortium claim, and we tell them what a consortium claim is meant to compensate. We don't have that here, and Justice Perry...
Why can't that be argued to the ALJ?
It can be argued to the ALJ, and in fact, I made reference to two opinions that we included in the record, really just for some additional elucidation, where that conclusion was made. The ALJ says, I have to conclude this is in fact a consortium claim because that's what makes sense at the common law.
If it's just a mother or just a father who files a claim, give them $50,000, and would that be error?
Would it be error if a single parent with no other parent in the picture just received $50,000? We have no guidance in the statute to tell us that. None.
What do they use to determine, the 100,000 is a cap, right?
Yes, sir.
So what do they use to determine how much an appropriate amount should be?
The practice, Justice Polson, has been that the $100,000 is always awarded in total, and it is almost always awarded as a lump sum, and we submit that's because of the paleness of the sum compared to the common law right it is replacing when those parents, by statute, lost their common law right. Because I think all of us can agree, when you have a severely injured child, a brain-damaged child, all of us can imagine the life that leads us to. $100,000, even if we're applying it to each parent, and in some cases a guardian, is not a very fulsome amount of money to compensate the parents for what they
But there's no
have
question,
lost.
as you said, that if the parent then starts to actually care for the child, leaves his or her job, that they can apply to NICA for compensation for the care they're giving.
Yes, Justice
Which seems to say that this can't possibly be for custodial care. First of all, it's a ridiculous amount for custodial care for a child from the infancy up to their majority. It's not even, but there are separate provisions for that.
And I might also note, yeah, that's exactly correct. The economic claim that the parents can make if they choose to provide or are able to provide these services is detailed in the statute. Might also note, we're thinking of the number here, the $100,000, and particularly when you have it, as Justice Quince noted in the hypothetical, if you had a single parent who just received half, that number has never been changed since 1987. When this statute went into place. So to focus for a moment on the St. Mary's problem that this court identified very squarely, we would suggest that if this court follows the precedent of St. Mary's, the notion that the simple math addition of an additional claimant can change your award, and in this case, have it, or in other circumstances, double it if you look at people collectively, is an arbitrary distinction. And the point that seems compelling to us is that the stated goals, admirable to the legislature, right in the act say, what are we doing here? What do we need to do? Why is the legislature taking away these common law claims? They're doing that, the legislators are doing that, because they want to reduce med-mal premiums. And it's important to note that under the statutory language, med-mal premiums don't contribute to this fund in any way.
You're in your rebuttal. If you want to save, you have about 4 minutes. Do you want to save that time?
Thank you, Justice.
Now here you just have to sit down. You don't have to shut up. Maybe across the street you have to do that.
That'd be difficult for most lawyers to do. Your Honors, my name is Wilbur Bruton. I represent NICA. Let me say.
Can I start with something that just is it's bothering me in this respect? The actuarial soundness of NICA.
Correct.
Do we have any idea in a typical brain damaged child case how much money is paid out for the care of that child from the time she or he is born until 18? Do you have that in the record?
Depending on the severity, it ranges from $3 to $7 million on a reserve, and those reserves are monitored, age, life expectancy is monitored, et cetera. There is no cap on the payments for the child. There is no cap on nursing care in the home. There's no cap on any care that's necessary for the child.
This is what I'm trying to figure out.
Is the actuarial soundness.
How could the idea that you're going to pay either $100,000 or $200,000 when we were talking literally about millions, multi-millions of dollars, which are admirably, under these terrible circumstances paid out, have even the remotest effect on the actuarial soundness of the NICA? Am I missing something on that?
I can answer the question, but it's not in the record. Just to be clear, the actuarial soundness is based upon how investments work. You've seen it with pensions. And the bottom line is we've been within $1 million of the 80% clip that stops NICA.
I can appreciate that, but as far as whether the legislature, in terms of this being on the equal protection argument, if it's, and we can talk about whether it's intended to be non-economic damages, because if it's economic, to me, I think you have a much stronger case. But if it's to be a one-time non-economic damage for this terrible loss, it certainly can be, it's not money that's paid out into the future. It is, you figure out partially in the course of a year how many children are born brain damage, and you make predictions about it. But to me, the thing that's going to affect the actuarial soundness is going to be whether the costs of medical care, nursing care, and everything else are going to go up in the 18 years from the birth there, not whether there's $100,000 or $200,000 paid to these cases at the outset.
Well, with all due respect, we've been following legislative intent since this bill was passed in 1988. And the staff reports, the legislative arguments, the debate that took place clearly stated when this bill passed back in 1988 that compensation is limited to net economic losses. Non-economic damages of pain and suffering are not awarded. So therefore, there aren't any. And the bottom line is that's where this all comes from.
So your argument is, let's go back to that, because that's to me a more important thing, that this was never intended to substitute for a loss of filial companionship.
No, I don't think so.
But that's how NICA has interpreted it.
Let me kind of roll into it. Yes.
That the NICA, who's charged with carrying out the plan,
right,
has interpreted this as being a single $100,000 payment, correct?
Correct.
And has interpreted the legislative intent as being only economic damages, not non-economic damages.
Correct.
Okay.
And that has been the way it's been since day one.
$100,000 is a part of economic damages?
Your Honor, let me kind of argue that, if I can for just a second. The legislature passed this, and we're dealing with state tax dollars. We're dealing with state funds. We're dealing with an appropriation through a statute that was set up that this court determined in the Coy case that the assessments on all the physicians and everybody else to set this up, plus the $40 million from the Insurance Regulatory Trust Fund, were all state tax dollars. So the legislature set up this sovereign immune entity, NICA, to pay these claims. They limited the amount to $100,000. Should that figure be higher than $100,000 in 2011? That's an issue for the legislature, because this is state tax dollars that are being appropriated.
Now, the question I think that's being raised this morning,
yes,
is a question if in doing that, there's an equal protection problem.
And
that's where we go.
And let me
ask the question, have you gone through other no-fault kinds of statutes like the workers' comp statute? And there are limitations by percentages for families in the event of death. So much even if you remarry, it affects it. If you have children, the children get some, so families are treated differently within that workers' comp. So if we would hold that this violates equal protection, then does the workers' comp death provision fall as well? I mean, because that breaks it down not as clearly as this. But
I can't answer that question because unfortunately I don't deal with workers' comp, and I'm glad I don't.
You said fortunately, right?
No, unfortunately I don't. But Your Honors, I understand the issues here on the limitations of the issues. of the amounts, but the bottom line is, the only thing that we're able to deal with in administering a program is what does the statute say?
Sure. Now, could you make your argument, because you were saying that this is economic damages, and I think either Justice Quince or Justice Lewis asked you how, if it's the custodial care is taken care of as economic damages, what does the $100,000 represent?
The statute is totally and completely silent on it, but when the administrative law judge in the two cases referred to by the appellant apportioned the $100,000 between the mother and the father, they did so based upon who was going to be the primary carekeeper. That's how they actually did it. Whether it's right, wrong, or otherwise, that's how they did it. Nobody appealed. Those are the only two cases in the history of NICA where there's been an apportionment. And so...
Apportionment that wasn't 50-50.
Correct. Well, there never has been, in my knowledge, a 50-50 apportionment. The check goes to both parents.
Well, how can that be if there's never been in a history of NICA's parents that either were divorced or never married?
Oh, yeah, Your Honor.
But they just haven't. I guess, the bottom line, I'm not being callous for Ms. Downs, but for most of the time, the question of whether you're going to get 50 or 100 or 100, when you're dealing with the magnitude of this loss, is whether it's 100 or 200. I think you'd agree it's hardly the kind of compensation that would take care of the non-economic damages or the economic damage.
Well, if we focus on the amount or we focus on the statute, I can only focus on the statute. Should the legislature increase it? Should it be a different figure or not?
But why would the legislature, if their intent wasn't to give a non-economic damage, why would they give something like this if everything else is payments to do with actual expenses? And I realize we don't have to, if we don't know that, it's why it would seem to me that that round sum of 100 sounds more like it's a non-economic damage, because in all the other statutes, when you have someone gets $250, but then they get all the economic damages, usually those round amounts are non-economic damages, not economic damages.
I understand that, and you're focusing on the money. I'm focusing on the sovereign immune entity that's dispersing state tax dollars.
I don't fault NICA for how they've administered this statute. We're here because either it's not entirely clear and the court needs to interpret it, or because if it is clear, there's a question as to whether it violates equal protection. And I think that's really, to me, NICA is, observed you as representing NICA. I think that you're doing it looks like an admirable job of trying to carry out the legislative intent and the NICA statute. So
I appreciate that. Let me kind of get into my argument and explain where I'm coming from, and I'll go to start with equal protection. I think the class is the parents, okay? That's the class, and there's not a single party within that class that's being treated differently. It's all $100,000. They're all similarly situated. And the administrative law judge has never ordered an award in excess of $100,000. That's been the interpretation. We've never had anybody rule on that in any appellate court. It's all gone up and said that's where it is.
Let me ask you this about the class that you say is parents.
Right.
If assuming that parents are divorced,
yes,
and whoever is the caregiver or the child lives with is the one who brings the NICA action, do you have to bring in the other parent, or
procedurally, NICA would bring the other parent in, and in these two cases,
assuming you can find the other parent.
Assuming you can find him. Otherwise, the parents or legal guardians are recording this, and the only two that's ever happened was Waddell and Wojcicki, and in that particular instance, it was estranged parents, and the judge apportioned the amount. And it was pretty much $95,000 to $5,000.
Okay, so assuming you can't find the other parent, NICA would give that one parent the $100,000, and the other parent would have no cause of action, for lack of a better word, against NICA in the future.
That's correct. And that person's probably not found, because we try to find them because we don't want to have that problem in the future.
I thought that really that the fundamental issue that we're looking at is whether the class of, if you have two parents, that each of them would receive 50, but if you only had one parent, that individual receives 100.
That's correct.
But those are the two different classes. You're treating married together people different than singular.
I don't think so, Your Honor.
Well, would you address that? Would you? Because I think so. I think that's what this is about.
Since it's a non-economic damage, I think we're dealing with the fact that there's an added burden, as the 5th District found, to caring for the child. And so if you've got a custodial parent...
What's the added burden?
Well, I think it's a little more difficult to take care of a child than an absent parent not taking care of a child.
But you've assumed it's economic damages. Let's just say we disagree with you and say this is clearly non-economic. Make the same equal protection argument and respond to Justice Lewis.
It's just a fund. As you argued, it's just a fund.
It's a fund.
Okay.
There's a class. The class is the parents. The parents are entitled to $100,000. If there's only one parent that's around and they file the claim, they're entitled to $100,000. That's the way we've interpreted the statute.
Well, I think the statute, again, you're going to make, I agree with you that it says award singular, parents plural, guardians plural. It's beyond me how you can interpret that differently. But the equal protection one is one that after looking at St. Mary's, and this is a little different because this is a no-fault kind of thing. I do understand that. But I'm really trying to understand, that can the legislature do this to certain citizens who are going to give you 100 individually, and others going to give you only 50, and you call it XYZ money. I mean, to me, it doesn't seem that they've designated anything.
I don't think anybody said that we're only going to give somebody 50. I think.
Well, that's the effect if there are two parents.
Well, no, the difference is the two parents.
They get it jointly, and somebody else gets 100 singularly.
Well, it might not even be 50. Like in one case, it was 95 and 5. So.
And that's because the judge weighed who was taking care of the child. That was the issue.
But the statute on the limitation doesn't really say that, though, does it? When it talks about award, it doesn't talk about this award being for who's taking care of the child or anything?
It doesn't say what it's for.
Right, it does not.
And that's why I'm trying to get to the issue of why I think it's a rational classification. Agree with me or not?
Go ahead, because I think that's where the test is.
Because I think that the reason for it is start again, this is state tax dollars that are being administered. And the legislature passed a law and made a determination. It's unlimited on compensation for care of the child. This is the only limitation in the entire statute. And the bottom line is, this statute is rationally related to the legitimate state objective because it provides compensation for these catastrophic injuries, and these injuries are catastrophic, and the high cost of custodial care. It also alleviated the medical malpractice premium. It opened the hospitals. This court, in the Coy case, when this case first came out, in reference to the fees, went through all of the exhaustive facts relating to how, when OB units shut down, the hospitals don't function.
We're not here, and Ms. Downs hasn't attacked the act. I thought what we're here is, was there a rational basis?
I'm trying to get there.
Well, then get there.
Okay, I'm trying to, because one of the functions is maintaining an actuarial soundness issue. That's kind of critically important on the payouts that go on. While this may be a smaller portion of the entire picture, it's part of the entire picture. But the legislature has gone throughout the act and gone to actuarial soundness numerous times, even to the point it shuts down the plan if you're not at the 80% cap. So NICA is a plan of compensation, and to hone in on one particular area of the entire plan and say that's not a rational basis that the legislature can qualify and satisfy in this particular area, then I think that's what's happening.
It could have been that they didn't think, listen, at that time, the idea was that you're going to give, for these catastrophic injuries, catastrophic amounts of money. Without
or it could be
without demeaning it, again, this $100,000, whether you get $200,000 or $100,000, is hardly going to be an adequate compensation for somebody who has a profoundly brain-damaged child. So now we just go back to, and I'm still not sure I understand, why is the discrimination not between parents who are married and parents who are single or divorced? Why is that not arbitrary if we assume that it's for non-economic damages?
Because I think you can only have two parents. And the apportionment issue that was done, and the only 2 cases it was ever done in, was based upon who cared more for the child. And so from a
Well,
real...
if you can only have 2 parents, then the idea whether the legislature really worried about the actuarial soundness on whether they paid out 100 or 200 for each of the claims where they're going to be paying out millions seems to be far-fetched as to a reason for having made that distinction.
Well, since I can't go inside the mind of the legislature, I can only assume that at that particular point in time, sovereign immunity was limited to $100,000 against an entity. And it's only been recently that sovereign immunity was changed by the legislature, but it wasn't changed in NICA.
But that would be $100,000 for the entire claim, correct?
For the claim.
For the claim, so that if several people are killed in an accident, now we're going, and they have, and someone else is profoundly brain damaged, there's going to be a cap. What is it? It was 100, and then how much for the whole incident?
Well, you referred to that issue in the St. Mary's case, which I'd like to go to next.
Well, I wasn't. Can you answer though when you deal with sovereign immunity?
Sovereign immunity is $100,000 of any claim or judgments or portions thereof when totaled with all other claims or judgment cannot exceed $200,000.
So if they were trying to come up with a sovereign immunity situation, they couldn't do it here because they were paying out unlimited amounts of money. This is a complete waiver of sovereign immunity, and we're not suing the state, so it really has nothing to do with sovereign immunity.
All right, Your Honors, I want to get to the St. Mary's case, but sovereign immunity was waived in the NICA statute only to the extent necessary to pay the claims, and the claims were statutorily set as to what they could be. In St. Mary's, the problem here is in St. Mary's, you had a statute that talked about any offer by any claimant to any defendant or any defendant's offer to any claimant to arbitrate, and the claimant was clearly defined by the law as any person who has a cause of action arising out of negligence. And what this court decided was that that statute was ambiguous, and it included any claimant, so therefore every claimant had a limit of the, I believe it was $250,000 or $350,000, whatever the number was, and therefore it couldn't apply to one claimant because of the totality of the statute in St. Mary's. So that's the reason the St. Mary's case is different from NICA. And I think if you focus on the amount of the money rather than how the legislature wrote the statute, you get into a different position than where we're arguing. We're arguing the statute. And we've also said that it's distinguishable because of the simple fact that you could have 1 to 12 claimants or more in a wrongful death action. And the wrongful death action that was cited to in the St. Mary's case in the state wrongful death action against the state was $100,000, and if you tie all the claimants together, it couldn't exceed $200,000. And in this particular instance, a class has been set up, and it's $100,000. Whether it should be more or whether it should be, twice, 2, 3 times that. My whole point is that that's a legislative issue in the statutory appropriation of state funds. And I don't know how to get there anyway except to say we're reading the statute. We deal with these people that have the children, they're very critically injured. It's heartbreaking, and I understand it. But we're trying to follow a statute, and what we've asked, and I know I'm running out of time, but what we've asked is if, we think our interpretation is correct, we think it's correct the way the 5th District did it, but if in fact you decide to make this not constitutional, this $100,000 issue, then the bottom line is we sincerely request that you make it respectively and not retroactively, because quite frankly, it's a lot of money, and actuarially it's a bad problem.
I don't think anybody that's not made the claim, I don't know that we do that, but I appreciate your, in other words, I don't think anyone that hasn't made this claim can come back and unless they've made it. We don't have retroactivity in, have we ever done it where we've made it retroactive?
We've been involved in certain cases that are outside of where we are right now, where people are trying to make it retroactive.
Okay.
How many, just as an aside, how many of these cases are we looking at every year?
where children are?
I can't tell you the number. They spike periodically for crazy reasons, but realistically speaking, we're in the neighborhood of probably, and don't hold me to this, but I think there's probably roughly 155 children currently being paid under the NICA.
Since 1987?
Don't hold me to the number, but I think that's what we're currently paying on. So however many it's been, I can't give you that exact number right now.
So if that's correct, the net effect of this would be 187 children.
Would be another $15 million.
From the past.
Yeah, and if it's retroactive, it's $15 million.
Well, okay, we won't. You have, with our help, used your time. Would you like to make some closing remarks?
Well, I just, there's other arguments that they use in their brief, and very briefly, I don't think we're here except on the certified question, and so I hope we won't go into the access to courts issue and all that, because quite frankly, we had a stipulation below with the plaintiffs because they wanted to challenge this issue. This is the only issue that they would challenge, and in their brief, they've challenged access to courts and other issues which are outside of this, and so I hope that you won't do that, although we referred to it in our brief.
Thank you very much.
We sincerely think that statute says what it says, and we hope you uphold it.
Thank you.
Thank you.
Rebuttal?
Very briefly, on actuarial soundness, we have in footnote 4 in our brief some information about the monetary status of the claims, and I do think there are 2 points worth considering. One is these claims are reserved as they occur, and that money is set aside, and that has been done. In 2002, there was about $600 million in that fund, and each and every claim had been reserved amount. We would also, we would also suggest that given the large numbers of these claims, which NICA, of course, admits, curing the constitutional infirmity that we're here about is a relatively small sum.
I mean, not the large number, the large amount of the claim.
Yes, I'm sorry, large amount of the claim, exactly, thank you. As for non-economic damages, if in fact the award we're talking about is for non-economic damages, then the parents under NICA have lost a valuable and compelling claim and received nothing for it on a non-economic scale. And so our suggestion is the problem with going down that path is it leads you arguably into a situation where you have to go and look at an entire act and its constitutionality as opposed to what we submit as the proper and narrow fix under St. Mary's, which is to find this amount applicable to each parent and do away with the arbitrary determination of class that this statute envisioned,
well, I guess
whether it thought it through or not.
His point is this, in terms of arbitrariness, $100,000 is an arbitrary amount. If in a situation where the parents are not married and they are either there's a father that was absent or they're divorced, all the time where there's insurance limits, and if you do plaintiff's work, you know, say the claim is $100,000 in insurance coverage, there are 2 parents, you got to say, well, geez, there's no way to compensate you, but this is all the amount we have, we're just going to have to apportion it. Why is that any different? It is, it's a meager amount, but $200,000 doesn't exactly solve the problem, and if 2 people are making competing claims, then the trier of fact has to do his or her best to apportion it based on who they think has the greatest injury or, you know, loss, so to speak.
But the problem with that, of course, is we have a wide swing. However small these sums are compared to the injury suffered, the difference between receiving $50,000 or doubling it to $100,000 in the instance of that particular individual is compellingly large, and in some cases can make a lifetime of difference. So the number is both small compared to the common law claim, but potentially very large when you take the fact that a parent could receive either $50,000 or 100,000 given the circumstances.
And I shouldn't have minimized that because I'm thinking in
right.
terms, as you said, the magnitude. But
Right.
I don't want to say that anybody in this day and age, that it's insignificant whether they
Right,
get 100
and very
or
briefly, I
200.
want to address NICA's claim that this statute is completely silent. I believe that's a quote. It is not. It says, quote, "For purposes of this estimate, the association should include the maximum benefits for non-economic damages." There are no damages in this statute that could possibly be characterized as non-economic
So
except
that's
this
your most
parental award.
compelling argument that they have characterized these as non-economic.
And so we respectfully request that you cure all these constitutional infirmities by construing this statute in accord with your prior ruling in St. Mary's, and that way it will work and be appropriate. Thank you very much.
Thank you both for your advocacy. The court will now be in recess.
Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU TV, and Florida State University.